Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Good morning, couch potatoes. How is everybody doing today? Happy Tuesday. Honestly, it feels like a Friday already. Yesterday it felt like 4 days in one. But good morning. We're here. It's only Tuesday. But between streaming and trying to catch up, fundraising planning, life, all of it, it's a lot already. And it's only Tuesday. I might need to take a break for last week and today to this week. Just have it like an actual good break or something like that. I don't know. I'm just kidding. I'd miss you guys too much. As you can tell, my voice isn't sounding great. I don't know if you can tell. I can tell. Um, so I might have to make more coffee breaks today than normal just to keep it, smooth or something. But super great. This is what happens when I take a week off. I don't really talk that much as a person, like at all. I barely even talked last week. And so when I do get back to streaming and I talk a lot, my voice is always like, what are you doing? What are you doing? We haven't used this very much in a week. Hello, Dan Montana. Good morning. You'll be in lurk mode. Well, that's fine. We love our lurkers, don't we? Hello, Stringer Bell. Good morning. Good morning. Well, today's going to be a fun day, I think. So we are, let's see, where did we leave off yesterday? Actually, it was Mike's side. Him and Omar were basically being like, "No, she sucks. Rule in our favor. If we're going to have a hearing, then we need live person testimony because she is a liar who lies." Basically, is what all 30-something pages we read boiled down to was, she lies, Your Honor. And let's get rid of the DVRO to begin with because it was all based on fraud. So today, we're in the, let's see here, October 7th, 2025, part of the timeline. And we're going to have Laura is filing an ex parte for a continuance of hearing, as she would, of course. Then there's some mini minutes for a hearing, no actual hearing because it's in California. And then some exhibit and witness lists, which, all right, interesting. But then there's a big motion in limine when it looks like Laura is telling the court why certain witnesses shouldn't be allowed. And I think that's going to be the banger today. I can't wait for her reasons. I don't like them, Your Honor. I don't want to hear them. I don't want them to be on the stand because they're just going to try to embarrass me and harass me. I don't know if that's what she says, but it's probably it. You just saw an ad for House of the Dragon. Yes. Was that this? Like on my show? Did you see? Because if they play House of the Dragons ads on Couch Court, they really know me very well. Yeah, we all love House of the Dragon too. Actually, you should join our Discord server, Stringer, if you haven't, because starting next week, we're watching both season 1 and 2 of House of the Dragons, and then obviously whatever day it comes out. What is that? The 21st, I think it is. We'll stream it every Sunday as it's live. So if you don't have the HBOs, I do. And we play it every Sunday in the courtyard when it'll start. So I'm very excited about it. I think I heard that the one battle, sorry, I'm like barely awake, Battle of the Gauntlet, I think is what it's called, right? Is like 25 minutes. That's like Battle of the Bastards time. I love that for us. I love it. So that is what we'll be going over today. Now, a few reminders in case you've been living under a rock the last 3 weeks, which if you have, hello. Glad you came out from there. This Saturday, June 13th, from 12 p.m. Eastern to 12 a.m. Eastern, we are hosting a 12-hour Mega-Stream fundraiser for Mike Marraccini and his legal bills. We had a big meeting about it yesterday. We've got the schedule mostly laid out. I'm so excited about it, you guys. It is going to be so much fun. I can't wait to talk to all of the people that are joining us. We're going to do some really fun things. We're also going to be auctioning off items throughout most of the day. So you can either just donate money or you can win an auction item and donate money. Either way, all monies is going to Mike that day. So that'll be a lot of fun. Also, under our community tab, and I'll ask you guys now. So one of the things we thought would be like really cool to do to show, this community is very supportive. Well, mostly very supportive. No, I'm just kidding. You guys are very supportive. Is if you want to write us any kind words of encouragement or support for the Marraccinis, you can email them to me or Winks, and our email addresses are here at the bottom. Tara, Tara, at tcwtmedia.com, or Winks, WINKS5813 at gmail.com with your words of encouragement or support. Or if you want to like record like a 2-minute video, we can play that during the fundraiser. But if you do email us and you do send us a comment, please let us know your YouTube handle name so we're not just saying your real name. If you do put your name, I'll only do the first name anyway. So I'm not going to put out your full name or anything like that, but I prefer your YouTube handle just because that's how I know you. I don't know what your government name is. So, but I thought that would be really a nice thing for everybody to do. So you can either email me or you can leave it under our community tab. That is just fine as well. Because we'll have like a special segment for that. Hi, Liz. How are you today? I hope you're feeling a little better in the hospital. Hello, babes. All right. Well, let's get into it today. I think that was all I had to announce. Sure. I'll probably remember something later. All right. So let's get into hello. Hello, April Fool's doll. That's a fun name. I like that. Good morning. I hope you're doing well. All right, so let's start with Laura Owens' ex parte application for a continuance of hearing because of course she can't show up. I mean, we'll find out why, but obviously she can't do that. Her schedule is just so jam-packed with all of her non-jobs and non-cleaning and non-boyfriends and non-everything. But let's hear why. You're sitting on 50 pillows like a queen. Like a queen, Liz. Let's hear why she can't make these 2 dates that I believe have been scheduled since on the timeline August, at least for a few months. She's known the date of these hearings. So I'm sure it's just a coincidence that, there is going to have to be live testimony. She'd have to take the stand. I'm sure she would never lie on the stand, and that her reasoning for why she can't be there is totally going to be legit. Do you guys think that's what's going to happen? You're like, no, Llama, we've been here for months. We know that's exactly not going to be what happens. Okay. Let's see. I don't need that open. I don't need that open. All right. So, hi, Raindrops and Feathers. Hi, how are you? Long time no see. Hope you're doing good. You're almost the bride to be, yeah? Or did that already happen? I don't remember. But I think you're a bride to be still, right? All right, so introduction. So petitioner Laura Owens respectfully requests that the court continue the long cause hearing currently scheduled for October 20th and 21st, 2025, and adjust all related deadlines. Now, side note, I very much appreciated that they were giving them 2 days, a 2-day hearing. Unlike over in Arizona for all their other hearings, they're like, both sides has an hour total, and that's it. That's all the time you get, which doesn't really make sense for a very complex case like this. But Arizona's like, no, we'll give you 2 days. So that's nice. I miss you too. Nice to see you. All right. So Laura says good cause exists under California rules of court because of Laura's medical condition. Okay, of course. Her father's recent hospitalization. And her ongoing yet diligent efforts to secure counsel through approved legal referral programs. What does that mean? Approved legal referral programs? Is that like a victims like group or something? What? And also, why can't you get a lawyer? I mean, you have so much money. They don't. Spoiler alert, they don't have any money. She actually files for a bankruptcy around this time too, if I remember right. Medical condition, right? April, like, okay. Now, this matter has been designated a long cause evidentiary hearing, not a short or summary proceeding. And given its complexity, the overlapping motions, and the public nature of the record, because those JFC cult people, you guys, out of control. Laura cannot adequately represent herself. I don't think those are the reasons why. I think it's you don't know what you're doing. A short continuance will allow her to secure counsel and participate fully and fairly. Remember, she filed this in July. This is October 7th. She's had months to retain counsel, but okay. Oh, so here's her factual background. Okay. A family medical emergency. Laura's father was hospitalized last week and continues to require 24/7 care. Okay. Laura has been assisting daily with his medical management. Who believes that? I don't. I don't. Oh, God. Could you imagine her taking care of you when you are sick, though? Oh. Okay. Laura's reason number 2, Laura's medical condition. Laura has been advised to receive urgent evaluation and treatment for gastrointestinal bleeding. Oh, well, that's not great. Not great. But also, if it's that urgent, how are you writing this whole thing out? I mean, you could just be like, I'm bleeding out in the butthole. I need to go to the emergency room right now. Do they let you just walk around with that happening? Don't they want to treat you right away for that? I would think so. It's never good. Never good. Hi, Lady in Gray. You're working. You just want to say hi and to tell everybody to hit the like button. Well, thank you. I appreciate that. I appreciate that. Let's see. 3 efforts to retain counsel. Laura has been declared indigent. Indigent. I can't say that right. Indignant. That's not right either. Okay. Indignant. There it is. By a court in Arizona. She has actively sought legal representation in this case through the San Francisco Bar Association's Lawyer Referral and Information Service, and all for the Family Legal Clinic. She contacted both by October 1st, 2025, and remains on their waiting list. Why'd you wait till October? Both have said they will be able to assist if she can wait 2 to 4 weeks. These are legitimate, ongoing efforts showing diligence and good faith. Yeah, no, but you filed this in July and you only waited till October to ask for help. Okay. Doesn't make any sense, but horse riding helps. Well, that's true. That's true. I heard that's the cure for beehole bleeding. Who knew? Hello, Buffy. How are you? Happy to see you here today. Complexity and public exposure of this matter. Now, this case has been designated a long cause hearing and involves multiple pending motions and evidentiary issues. It has also drawn public attention through a group known as Justice for Clayton. That's you guys. Which reposts and comments on case filings. You guys, why would you do that? Oh my gosh, it's almost like the public has an opinion about things. Call me crazy. The harassment and publicity surrounding this matter are described in prior filings by attorney David Gingras. Laura requires counsel to ensure filings are accurate, complete, and not misused publicly. Should have thought, I mean, okay, so the whole Clayton thing happens June 2024. A year later, she goes to renew this DVRO, making it all about how Mike showed up to that trial, even though he was subpoenaed. And now she chose to renew that. He had a lawyer pretty much from the get go. And now all of a sudden she's like, yeah, I think I'm going to need a lawyer. Like, girl, yeah, this is not your first. She does this all the time. And it really pisses me off because with each case, she acts like, oh, I don't know what to do. I've never done this before. And it's like, girl, you have been in court more than a lot of people. You know exactly how things are going to go at this point. Hi, Winks. Good morning. Good morning. Indigent, pronounced poor. It's the fancy word for poor people. I love how she likes to say she's poor when it's convenient. Other times, she's not that kind of girl. All right. And 5, efforts to resolve informally. Laura contacted opposing counsel Omar Serrato on October 6th and 7th, 2025, to request a short continuance while she secures counsel and addresses these medical issues. Counsel has not stipulated to a continuance as of this filing. Well, I wonder why. They were like, fuck no, I don't think so. We're ready. You're not ready? That's your problem. Here are some legal standards and arguments. Circumstances that may indicate good cause include the unavailability of an essential lay or expert witness because of death, illness, or other excusable circumstances. That's nobody. The unavailability of a party because of death, illness, or other excusable circumstances. I guess she's trying to go with not available because I'm bleeding out my beehole. 3, the unavailability of trial counsel because of death, illness, or other excusable circumstances, the substitution of trial counsel, and 6, a party's excused inability to obtain essential evidence despite diligent efforts. Okay. Laura's situation satisfies several of these examples, does it though? Her temporary medical unavailability, her father's hospitalization, and her documented, diligent attempts to secure representation all constitute excusable circumstances under the rule. Further, the rule directs the court to consider all the facts and circumstances that are relevant, including the proximity of the hearing date, whether there have been previous continuances, the length of the continuance requested, and whether the interest of justice are best served by a continuance. My answer to all of those is no. I don't think so. Diligent doesn't exist. I love your dictionary, April. You should think about just writing your own. You and Dan Montana here can pair up, just write a whole Laura dictionary because she likes to also use a lot of words that she doesn't know what they mean. So you can be the April Dan Montana Dictionary Edition. Oh, that one's real hot. Okay. Ooh, I'm fine. All right. Here, for some reason, the hearing is less than 2 weeks away. No recent continuances have been requested. Petitioner seeks a modest 45-day continuance. Yeah, 45-day continuance is modest. And Marraccini will suffer no prejudice, while Laura will face extreme prejudice if forced to proceed unrepresented in a multi-day evidentiary hearing. Okay. If you say so, if You say so. She's like, no, Your Honor, I can't do it. You guys are on it. Good. I love that teamwork. That's what we're all about here is teamwork. Makes the dream work. Laura Owens lexicon. Yes. Hi, virtual juror says, but I love words. I know all the words. See me use them. She does that so much too. You're like, that's not what that means, babe. All right. So, given these factors, the interests of justice are best served by granting the continuance. Part 4 Prayer for Relief. Laura respectfully requests that the court 1. Continue the long cause hearing currently set for October 20th and 21st, 2025, for approximately 45 days or such further time as the court deems appropriate. Now, there is more than 45 days from the time she filed this to, the beginning of October. So, can she use those 45 days wisely? Probably not. Or such further time as the court deems appropriate. 2. Adjust all associated deadlines for witness lists, exhibits, and briefing accordingly. And 3. Grant such other relief as the court deems just and proper. Okay. All right. Well, I'm going to go with the answer to that was no. Just a hard no. But she also has this declaration, which I don't know what's different, but whatever. We're going to read it anyway, of why she feels she can't make it, because this was filed along with that. So let's see if there's anything new. I, Laura Owens, declare that she's the petitioner of this action, blah, 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 blah. Family medical, my father was hospitalized last week and continues to require significant care. I have been assisting daily. My medical condition, I've been advised to receive urgent evaluation and treatment for gastrointestinal bleeding, and I'm undergoing ongoing medical testing and care. Oh, okay. Efforts to retain counsel, that's pretty much all the same. Long cause, complexity, and publicity. This matter has been set as a long cause evidentiary hearing with multiple pending motions and evidentiary issues. That's all the same. Meet and confer. She tried to get a hold of Omar, but he was like, fuck no, we're not continuing this. Good faith. She's asking for 45 days to retain counsel and prepare witness lists and exhibits. And that's it. And then this page, which looks like a sky, apparently. I don't know what that's about, but okay. All right. So there's that. Then a few days later, there is these many minutes from court. Apparently, they had a hearing, it looks like, on Zoom on, I don't know why this says October 10th, but here it says October 16th. So I'm not really sure what that's about. So whatever they're going to talk about is motion for leave to intervene, sanctions, disciplinary referral to state bar, moving party, David Gingras, motion to disqualify David Gingras, moving party, respondent, Michael Marraccini. So one of the things I didn't include in this part of the timeline for this story, because we didn't have much time before the fundraiser, is David Gingras is still around. He's not entirely representing her at first, but it's pretty obvious somebody wrote some of those earlier things. And so then he's talking about, oh, I'll come on and represent. Well, then there's a bunch of motions filed. We'll save those when we come back to the 2025 timeline later. But Omar and Rachel are being like, no, not this guy. He shouldn't be allowed to represent her. Like, no. So there's a lot of fighting going back and forth. So I guess that could be why she's like, oh, I couldn't get these other lawyer resources until October, now that I think about it, because she was hoping David could represent her, but that was a no. So there is that. Hey, Rob, how are you? Speaking of another person who will be at our fundraiser, happy to see you. You'll be hearing from us very soon, but happy to see you here. Not today, Satan. Not today. Oh, I'll tell you what. June is a garbage month this year. I'm just going to put that out there. I'm already over it. I don't understand why not good things keep happening. I don't understand why some people are just assholes to be assholes for no reason whatsoever. And I'm just already over it. My summer break is not turning out to be fun. Just want everybody to know that. Except for hanging out with you guys is a lot of fun. So, all right. So all remote appearances are conducted through Zoom. No calls or objections. Hearing appearances. Laura is present by video in pro perp, so by herself. Mike is not present, but Omar is present for the video. All right, so here's some findings and orders. Having read and considered the pleadings, declarations, and other evidence submitted in this matter, the court makes the following findings and orders. The tentative ruling is adopted. Okay. The court hears oral arguments from counsel Serrato and Laura regarding the upcoming trial set on October 21st and 22nd. Man, stupid California. I would have loved to watch this. Just watch Laura like bumble around of why she can't do it. Oh, stupid California. Additional orders by the court. So both parties are to exchange and file their list of witnesses and exhibits list 10 days before the hearing. The court permits out-of-state witnesses to appear via Zoom. The court notes that looking at the basis for the reissuance of the original DVRO, Laura needs to show to the court by the preponderance of evidence what happened during the renewal time, and since then, that makes Laura feel that she needs the reissuance of the DVRO. Oh boy. The court will hear live testimony from both parties, including witnesses during the trial. With regards to the CCP motion filed by Marraccini, Laura indicated that she was not properly served. Ugh, that's another one of her stupid favorite arguments. I'm sorry. They didn't get it to me. I don't know why. It just never happened. Ugh, so annoying. And the court confirmed that there is no service filed on the docket court. Well, fine. Counsel Serrato indicated that that Michael Marraccini is withdrawing the CCP motion. The court strongly suggests that all parties appear in person and third-party witnesses may appear via Zoom. Laura indicated that she has 8 to 10 witnesses and respondent will have 8 witnesses. The court requested both parties to streamline the number of witnesses prior to the trial, and the court shall prepare the order. Tentative ruling. Motion to intervene denied. So that's where she's like, no, sorry. David Gingras, no, you can't. Intervention requires direct and immediate interest in the litigation. This matter is from a witness to the litigation and is ancillary. Okay. So motion disqualified, denied without prejudice because the motion was premature. And a motion to strike sanctions moot as motion to intervene is denied. Oh, them and their love for the word moot. Moot. The virtual juror says, is Gingras licensed in California? Yes. He is in California, in Arizona. And we know that because we read one of his first blogs where he was like, well, I passed the bar the first try, both in California and Arizona 2 times. So, yeah, he does have his license in both of those. If not, he'd have to have a sponsoring attorney to have him admitted pro hoc. Who's sticking their neck out for this? I mean, that's true. But he is licensed there, so he doesn't have to do that. But I've seen so not all like lawyers, for those that don't know, like you can't go state to state to practice. If you get a case in another state, then a different attorney and firm basically have to sign something and say, hey, we're sticking our firm and our license, everything out for this other lawyer. So it doesn't really happen that much. I've only seen it with Karen Reed, right? So Alan Jackson, right? California attorney. Yannetti was like, that's fine. We'll we'll say that's fine. He can come. And I think, was Alessi from Massachusetts too? Or was he from, I don't feel like he was. Where was Alessi from? And then there's we had a doctor here, Dr. What was his name? Husted or something? One of those doctors where they said they were killing patients or whatever up here. And this was a few years ago. And Jose Baez was one of his lawyers. So one of the Ohio firms had to like let him in up here to represent the guy. And I think the guy was found like not guilty. So, oh yes, DG is currently licensed in California. Now, he has the bar complaints in Arizona though, right? Not California. Like I know he's up, his bar license stuff is like at the end of this month. Is that just Arizona? If I remember right. I feel like I've asked this question before and I should know the answer, but like my brain is just, it's like, nope, nothing for you today. I'm not being an asshole just to be an asshole. It happens. Okay, I don't know what that's in response to, but okay. He thinks very highly of himself. Someone has to. Well, that's true. That's true. Oh, okay. So Alessio is New York. Okay. And Bedreau is New York as well. Oh, okay. Okay. I wonder in the Northeast, since they're such smaller states, if it's more common for lawyers to practice in all the different states because they're like right by together, or unlike the rest of the United States where it's like we got 400 miles before the next state. Rob says, yes, the Arizona bar complaint, but depending on the outcome, it's possible that California will revoke his license too if you were to practice there, if I'm not mistaken. Okay. Interesting. Interesting. Oh, I see what you're saying. Puffy says, you said you don't know why people are being assholes just to be an asshole. And you are over the month of June. Now I understand it. You're not being an asshole just to be an asshole. You're never an asshole, Buffy. All right. So this is going to be Mike Marraccini's witness list. Let's see who's on this witness list. Now, spoiler, we know that this hearing never happens because Laura can't be bothered to show up. But we're going to read this anyway because I want to know what it would have been like had it have happened. Ooh, that would have been amazing. The virtual juror says, lawyer, does ProHawk work quite a bit from what he said on stream. Oh, okay. Okay. I mean, I don't think hi barbecue queen. I don't think with Gingris's history that too many people would be like, yeah, let's sign you up to my firm. Yikes. It's very common. Well, common-ish. People do it. Okay. Now, how did I bring that up? I didn't. Oh, it's probably my space bar. All right. So let's see who Mike's side was planning on calling. Himself, because that's always the case. His purpose is to testify regarding the history of the relationship with Laura. Oh, I guess I don't need to leave that up. Well, I mean, I could, but I don't need to. To testify regarding the history of the relationship with Laura, denial of all abuse allegations, compliance with prior DVRO orders, and evidence of Laura's fraudulent conduct and retaliatory motive. Estimated time, 60 minutes just for direct. Okay. Next, they plan on calling Laura, which again, that's pretty normal, for cross-examination regarding prior false statements under oath, fabrication of evidence, pattern of fraudulent claims, and the absence of any objectively reasonable fear of future abuse. And they estimate their cross is about 120 minutes. Oh, man, we were robbed of the glory that would have been to watch. Oh, man. Then they would call Greg Woodnick as a rebuttal witness, if need be. His purpose would be his expert opinion on Laura Owens' pattern of fabricating abuse allegations, misuse of court processes, and unreasonable fear under the family code, corroboration of finding in Arizona paternity litigation. And they say, We could probably cover that in 30 minutes somehow. I also love how he's an expert in Laura. I know that's not what they were saying, but that's what I feel like. Yeah, like I've dealt with her so much. Hi, Pam. Good morning. Hope you're doing well today. And then 4, they would call John Berryhill, a digital forensic expert, whose purpose is expert testimony confirming that multiple documents and digital exhibits submitted by Laura were fabricated or altered, including falsified medical letters and ultrasound images. Uh-oh. Uh-oh. I think we know why she didn't show up. Could easily catch some of those Cali charges. Next would be Terry Bowe, Arizona investigator from Maricopa County's attorney office, to testify regarding the criminal investigation of Laura Owens, culminating in a May 2025 grand jury indictment charging her with fraudulent schemes, forgery, perjury, and evidence tampering to explain the investigative findings showing a deliberate pattern of deception relevant to credibility for 60 minutes. Man, this hearing would have been the best. Dave, hi, how are you? I've missed you. Have you been out riding your motorcycle a lot? I bet you have. You're like, yes, feeling all the wind and everything. So happy to see you. Hope you're doing well. Next on the witness list is Clayton Eckert, whoever that is. I've never heard of that guy before. Fact witness and a victim of Owens. His purpose would be to describe Laura's false paternity and abuse claims against him, her use of forged evidence, and identical behavioral patterns demonstrating lack of credibility and absence of genuine fear. And their estimated time is 60 minutes. Next would be Greg Gillespie, another victim of Owens. His purpose is to testify regarding Laura's false pregnancy and abuse allegations in 2021, submission of a forged ultrasound, and retaliatory misuse of protection orders, further evidence of her fraudulent pattern. And then Joan O'Neill, a recanting witness. Oh, I remember her. Joan was the friend, right? I think that wrote a witness declaration in the original filing of this, where they were out to eat and Mike was around and staring at them. It was terrifying. Well, Joan is going to come as a recanting witness for Marraccini to testify that her 2018 declaration supporting Laura's DVRO was false and authored by Laura, establishing extrinsic fraud in procurement of the original restraining order. Estimated time 20 minutes. Well, I feel like there's a whole lot of criminal charges just in those witnesses alone. Yikes. Yikes. Of course. I think Buff and I were both like, is she real? Like, is this even how's she have friends? Quite frankly. Well, turns out, and she's real, but she didn't write anything. Oh, which leads me to Napkin Lady. Maybe she is real, but Laura just made up all the bullshit and filed something in her name. If she did it for somebody she knows, why wouldn't she do it for a stranger? Hi. Yes. You haven't made it this far in the timeline. You have a lot to catch up on. I'll tell you what, girl, we have been covering this since February. Okay. And we took a little pause in the timeline because we've been going in order as well. I know you do timelines. And technically, we still haven't gotten to Clayton's trial yet. Several months later. So Dave says, oh my God, is this another one of Laura's victims? Man, she's not. Yes. Actually, Dave, this is the first one. I think you were with us, the first guy we talked about, Mike Marraccini, and she gets a DVRO on him. Well, last year, she goes to file a renewal, a permanent one, for no freaking reason. So she's crazy pants. It's like the kids in the back of the car. Mom, he's looking at me and it's so scary. Oh, so scary. All paid actors. Pretty much. Tuesday, Sai. Hello, Echoes. How are you doing today? Hope you're doing okay. I'm doing okay. We're all doing okay. That's fine. So that is who they would call. Man, I really do wish we would have gotten this hearing. Been awesome. All right, so here's their exhibit list. So they're going to have an under advisement ruling from Judge Mata, the criminal indictment from Arizona, correspondence from Dr. John Chung Chan, which they said is a forgery. Same for correspondence with Dr. Rebecca Yee, MD. They said that it's another forgery. The San Francisco police case number, I'm going to go with that's when Mike called the police for a restraining order. An image of Laura with redness around her face, particularly her right eye. Digital forensic reports. Chicken soup for the soul story. Petition for order of protection against Clayton. Subpoena issued for Mike to attend the trial as a witness. A civil complaint against Greg filed on Laura Owens on August 21st. Oh, that should say 2021. That's okay. Petitions for order of protection against Greg. Positive pregnancy test by Laura. This would be when her and Mike were dating. Text message from Laura claiming concerns of a miscarriage on July 14th. Another text message of her claiming concerns of a miscarriage and on her way to the hospital the day later, as one does when they're miscarrying babies. I know you just wait till the next day. Who doesn't? You're so out of the loop. Don't worry. It's very easy to be in this case. The virtual juror says it expired before she filed for a renewal. Okay. Let's see. You're hanging in there hour to hour these days. I feel you. I'll feel you. I'll tell you what. I don't know if we've entered a new dark timeline, but I don't like it. How many of us broke mirrors recently? I don't understand where it's all coming from, but that's okay. We're here to be together, and that's fine. We'll just be together. Let's see, a Facebook post with Laura at a KGO celebration for Ron. Oh, we saw a lot of this already in their response to Laura's filing. Text message from Laura claiming her twin pregnancy was no longer viable and that she would take abortion pills. Text message by Laura claiming that the abortion pills did not work because, of course not, for some reason. Laura Owens' deposition for the Eckerd paternity case, where she claimed she saw Dr. Chan and had the oophorectomy and was treated for ovarian cancer. No. Equestrian rider reports during 2016. Oh, that's right, because we did go over those. And so during this time where she's pregnant and miscarrying and the babies aren't viable and we're taking abortion pills, all these things, she's competing literally every week for months on a horse, which it's not something that would probably happen. Petitioner for order of protection by Greg against Laura. Text messages from Laura to Michael on July 6th stating she loves and trusts you. Those are words I never want to hear her say to us, ever. Text messages from Laura stating love you. They say, love you. I'm horny, baby. I wish we could get dinner. So those. An email from Laura's attorney, David Gingras, stating Laura was willing to speak with him directly, which was a violation of the current restraining order because they were trying to trap him. Laura's sent inbox containing tips about the Clayton Eckerd paternity update, stating she is the anonymous woman around 2023. State's notice of disclosure and request for disclosure from Arizona. Text messages by Laura regarding inpatient psychiatric therapy. Declaration of Laura Owens about what happened, that was quite a read. Findings after trial by Judge Mata and a petition to court order paternity against Clayton. Now, we have been over all of those, either when we've covered Greg, we've covered Clayton, or at the beginning, just like maybe a few episodes before this one. You can find those in Marraccini's response to Laura's filing of this stupid DVRO. Let's see. Mercury retrograde starts June 29th. The pre-shadow vibes start showing up on the 12th. Well, girl, I think they've already been around. Okay. I think they came earlier than that. I don't know. Okay. So that's what they're going to bring to trial. Will want to bring to trial, and who. Now, let's see who Laura's going to bring, shall we? This should be interesting. All right, let's make it one more bigger. There we go. So, her first witness is going to be David Gingras. So that's a choice. Her former counsel and fact witness, she's saying it'll take 60 minutes. That he's licensed in Arizona and California, who represented her with Clayton. He will testify that on April 19th, 2024, Marraccini's attorney, Randy Sue Pollock, confirmed in writing that my client will not be testifying in the Arizona paternity case. Okay, people can change their mind. Despite this assurance, Marraccini traveled from California to Phoenix and appeared in person at the Maricopa County Superior Court on June 10th, 2024, where he sat, hold the phone, approximately 20 to 25 feet from Laura for over 2 hours while she testified. So scary. Without permission from the issuing court and in direct violation of the active San Francisco protective order prohibiting all contact. Right. Okay. That's just simply not true, but okay. Mr. Gingras immediately contacted court security and local law enforcement after Laura became visibly distressed on the stand, providing documentation of the active order and requesting enforcement. Okay. If you say so. Laura brings mommy. Is there mommy on the list? Probably. My mommy's here. Oh, Laura the liar, bringing the liar of all liars. All of the liars. Hello, Louise. How are you doing? Happy to see you here. You're late, but catching up. I love that. No such thing as being too late. Following this incident, Marraccini publicly admitted in a recorded interview with media figure Megan Fox that he attended the hearing knowing he was not going to testify. I don't remember what exactly he said in that. I'm actually going to be watching that tomorrow to prepare for the fundraiser. But it was only a 2-hour hearing, wasn't it? Or less than 2 hours. And they had a bunch of witnesses. I think somebody said, because we haven't watched it yet, I think somebody said they didn't even get to their side of anything, really. So maybe, you said that for an hour and you're like, well, time's almost up. I knew I wasn't going to be saying anything. I don't know if it was like that or not. So Mr. Gingras also opposes knowledge of Marraccini's involvement in providing a laptop to a forensic examiner that resulted in 2,489-page extraction of Laura's private text messages, which were leaked online to the group Justice for Clayton, which is dedicated to harassing Laura. Also, I haven't been able to find these text messages, so I don't think that's actually what happened. But also, if you're texting and emailing somebody, is it really that private? I don't really think it is. Their second witness would be Michael Marraccini. That's fair. expected to be cross-examined regarding his continuing violations of the San Francisco Protective Order, his repeated public misrepresentations about Laura, and his ongoing use of coercive control and reputational abuse to circumvent court restrictions. Oh, that's a new one. Never heard of reputational abuse, but okay. Like, girl, you have ruined your own reputation, to be quite honest. You did that almost immediately when you decided to go public with all the Clayton stuff, and Reddit was like, girl, you lying. Hmm. And I'm sure those, at this point in time, 7 felony charges are just not ruining your reputation at all, I guess. Excuse me. Virtual jurist says, if you're texting and emailing and it finds its way into a court filing, right? Jesse Proctor, right? Right? They say you should only put things in writing if you're okay with them being read in a court of law. That's what the little saying always goes. And they're right. Though I do kind of hope in some magical way some of my Discord messages find their way into a court document, because I'm always changing my name to something ridiculous that I wanted to be read in court so bad. Just the name. I never say anything of importance. But it would be fantastic. Hi, Teresia. I hope you're doing well. Hello. Thanks for joining us this morning. Happy to see you. So, Marraccini has engaged in a sustained campaign of post-separation harassment, including a 2.5-hour interview with media figure Megan Fox, during which he discussed the protected case, disclosed private details about Laura's mental health, and made false, humiliating statements designed to damage her reputation. Oof, okay. In the same interview, Marraccini admitted that he traveled to Arizona for the June 10th, 2024 Owens v. Eckert hearing, despite knowing he, quote, wasn't going to be testifying. He neither sought nor obtained authorization from the issuing San Francisco Superior Court in violation of the active restraining order prohibiting contact and proximity. His deliberate disregard for the order and court jurisdiction constitutes a willful violation of these codes, reflecting ongoing coercive control and intimidation. Okay. She just makes Mike out to be like a fucking menace. He's like anything but that. But she just makes him sound just like the most menacing person on the planet. Hi, say cheers. Good morning. Good morning. Everybody aspires to be mentioned in court documents like honk my meat, right? Honk my meat, silly goose tits, depending which server they use my stuff from. One would say not a grandpa fucker, which is a Real Housewives reference. If you know, you know, but I would love to see, I'd love to see her read out in court. It'd be so funny. Echo said I had a show title and thumbnail make it into a Gingras filing against Marraccini along with Lauren and Ducky. Oh, those must be the motions I was just talking about where I excluded them for now of him trying to like get on the case or something like that. And they're like, no, I had to cut that from this to prepare for the fundraiser. But we will be going back over it. And I didn't know you all were in there too, because we read one. I think it was just Lauren and Bruce who were mentioned in that one, I think. But oh, that's interesting. That is interesting indeed. Did you print it out and put it on your fridge or frame it? Did you do that, Echoes? Because if not, you should. That's when you know you've made it. Now, in pleadings filed through counsel, Marraccini further alleged that Laura traveled to New York to confront his employer's HR department and asserted that she has pursued communication, harassed, and publicly confronted him, claims that are entirely false, of which means they're probably entirely true, but okay. Laura has had no contact of any kind with Marraccini since 2018, has never known his employer's name or address. Girl, it is not that hard to find that stuff, okay? And has not initiated or encouraged any communication or confrontation. These knowingly false statements to the court illustrate Marraccini's ongoing fixation and continued efforts to weaponize litigation and public narrative to punish and defame Laura. Well, if that's not the pot calling the kettle black, but okay, girl, that's literally what you weaponize litigation more than anyone I've ever seen. That's for sure. Okay. All right. Bold claims. Marraccini's conduct, including the willful violation of a standing protective order, public exploitation of confidential material, and dissemination of defamatory narratives, demonstrates an unbroken pattern of coercive control and reputational abuse, warranting renewal and extension of the protective order under this family code. Okay. So dramatic. Oh, punted buttons. Hi. Oh, praise be to buttons. I love buttons so much. Hope you're doing well. Oh, that picture. That picture's rough. Oh. Echo says he accused Omar of conspiring with content creators to spread defamation of Laura and some such nonsense. I have a copy in my archives. The bump of subscribers was a nice byproduct. Oh, we'll be covering all of that again. So I can't wait to read it. I did not know that. I love it. You guys are all part of the lore. Takes one to know one, right? Do we know if Lowe spoke to his employer's HR? I don't know. I don't know. I wouldn't be surprised if that happened, just because she has a history of literally going after people's jobs that she's been with in the past. She did it to Greg. She did it to Clayton a few times. To Clayton, because first she tried to do it with the Arizona Real Estate Board or whatever they're called. I forget. And then she tried to do it to him. Well, she did do it to him when he was going to give a speech for mental health awareness for some foundation or whatever. And she contacted them and told them what was going on. And then they said, no, thank you, Clayton. We don't want you here. So I wouldn't be surprised. Is it confirmed? I don't know, but probably. I don't know why they would submit it if it wasn't, but I wouldn't be surprised. I thought it was cute. Well, buttons it's cute. Buttons. Oh, I love that part of the story. All right, so 3 family witnesses. Okay, so Laura plans on calling Peggy Marraccini, who I'm assuming is his mom, and Stephanie Ash Marraccini, now Scallion, which is his sister. We know because she also wrote a witness declaration in the 2018 case. Respondent's mother and sisters. That's right there. 45 minutes total for both of them. Okay. They are expected to testify regarding their close and frequent relationship with Laura during her relationship with Marraccini, including multiple family gatherings, dinners, and shared events between the Marraccinis and Owens families. Does she talk about taking them to the House of Prime Rib? Probably. Both women personally witnessed Laura experiencing a grand mal seizure in Petaluma, California on May 13th, 2017, shortly after an incident of physical abuse by Marraccini. Okay. Now, Peggy sent her son a text message the following day stating, I don't want you to be my son because of how you treated her. Yikes. What? Okay. Which even, this is from Laura, so there's probably a lot more context to that she's leaving out. So let's not judge Peggy too much yet. What? Which even Marraccini's own witness, John Berryhill, acknowledged as authentic. Her contemporaneous message to Laura described her as so loving and caring and so blessed you are home with your sister and daddy, confirming the seriousness of the relationship and undermining Marraccini's current claim that it was casual or delusional. Laura also retains multiple voicemails from Ms. Marraccini, many recorded after she had distanced herself from Mike, in which Ms. Marraccini pleaded for renewed contact, reflecting both emotional distress and implicit recognition of her son's culpability. What you did? What, Laura? Are you serious? You turned his mom against him? Oh, disgusting. Ew. Ew. I hate it. Hi, Skybell. Happy Tuesday. Hope you're doing well. What? Why did she? Ugh. Ugh. I don't like that. Now, Stephanie, his sister, also socialized frequently with Laura, borrowing her car, dining together, and exchanging messages acknowledging Marraccini's validity. But, like, here's the thing with people who are abusive, all right? Because we read a lot of those messages between Mike and her, ones that she submitted to the court, which was, I don't know why she would ever have submitted them because it makes her look like the abusive asshole with her emotional manipulation constantly. And, many people who are in abusive relationships and they're like, oh, but the abuser is like such a nice guy, blah, blah, blah. And it's like, yeah, they show you that for a reason. Because later you believing that they're going to use against the person they've been abusing and be like, look, everybody else likes me and believes me. So I must be right. Even though, I'm lying, I'm right because everyone else I've convinced. So what are you going to do about it? They do it all the time. And it's gross. It's very, very gross. And I feel like that's what happens there. There are no bounds, Rob, right? How many of you, I know some families are closer than others, but like I have been with Elbow Feet for 14 years. I can count on one hand how many times I've called to talk to his mom that involved something about our relationship, but it was more about like him. Like, I do not call her, not because I don't want to talk to her or anything, but like, there are just some things you just don't reach out to the other person's parents about. And it's weird to me because remember, she tried to do this with Clayton's family too. Oh, reach out to his mom, his dad, asking if they wanted to come to the ultrasound, talking mad shit about their son. She tried to do that with Clayton and his mom. And she did it with Marraccini and his mom. Another pattern. Talking about patterns, Laura. Queen of patterns over here. Hi, lady. Hope you're doing well. Good morning to you. All right, where was I here? Since 2023, Ms. Scallion has aligned herself with online harassment networks, defending Marraccini and targeting Laura, including Justice for Clayton. How fucking dare she? How dare she support her brother in truth and justice? Posting under the handle Justice for MM. All right, well, that's not a bad handle. She has publicly identified herself as Marraccini's sister and leaked previously unseen photographs she personally took of Laura to the Justice for Clayton official Instagram account. These included images from a May 2017 horse show and a private birthday dinner, confirming her as the original source of private material later used to harass petitioner. So So she's saying, well, Stephanie had taken pictures of us and then she put them on the internet. Who does that? Who takes pictures of people and then puts them on the internet? Literally everybody, Laura. Literally everybody. Oh my goodness. It was private though. Okay. All right. It's another one. Oh, dictionary people. Damn Montana in April. You're going to need to work on a new definition of that because I don't think she knows what that means. Now, taken together, Peggy and Stephanie Marraccini's prior statements, actions, and communications provide direct, independent corroboration of Marraccini's abusive behavior and evidence of coordinated, ongoing efforts by his family to intimidate Laura and undermine the protective intent of prior court orders. Their testimony collectively supports renewal of this by demonstrating that the abuse has persisted both directly and by proxy. Okay. Sure. If you say so. You know what's interesting, Laura, is that Stephanie is on the internet writing, defending her brother, her sibling. What's your sibling doing, Laura? Or is your sister trying to clear your name? Hmm? Hmm? Just saying. Do I think Sarah needs to do that? No. But I just find it very funny. Is all. She can't comprehend that a sibling would do that for another sibling, is what I think. So if you're in public, you have no expectation of privacy. Take it up with the Supreme Court, Laura. Take it all the way to the big one. Right? Like, no, it doesn't mean anything. Dan Montana says public means fair game of photo and video taking. Right? No. Yeah, it's already been like ruled on a lot. But okay. Callie. All right. Callie now McLean. I'm not going to try with her original last name. Former partner of Mike for like a whole 2 days or 2 weeks or something. Now, she is a former intimate partner of Mike who independently contacted Laura to confirm that Laura's prior warnings about Marraccini's behavior were accurate. You remember this story? If not, go look at the first 4 videos we did for Mike, where we covered all the 2018 and 2020 stuff. And the fact when he started dating Callie is Laura lost her fucking mind. And then she like reaches out to her and it's like, I'm just trying to warn you because I wish somebody did it for me, and would like send her, pages and pages of this long story. And Callie would just be like, okay, thanks. Okay. Weird, but okay. Now, in her messages, Ms. McLean stated, some things happened, and I would prefer to stay far removed from him. Oh. And I just wanted to say thank you for giving me the heads up on Mike, and I apologize for not believing you at the time. Did she really say this? Woman to woman, I just want you to know that I appreciate what you did. She also wrote that she blocked him on every platform to avoid further contact. Although the communication occurred in 2018, Ms. McLean's account remains highly relevant under the family code because it independently corroborates the long-term pattern of coercive control, emotional volatility, and retaliatory behavior that continues to drive Laura's ongoing and reasonable fear. I feel like if she had those messages from Callie, she sure as fuck would have used them in 2018. I don't know if they're real. I don't know if they're even real. I don't think so. Her testimony provides objective validation from a separate partner who, after direct experience, chose to sever all contact for her own protection, underscoring that Marraccini's behavior presents an enduring threat, not an isolated past event. Okay. Thanks, ChatGPT, for that one. Julia Brozick, that's a fun last name, Competition Safety Coordinator, United States Equestrian Federation. Okay. Sure, why not? Expected to testify as a neutral records custodian and expert witness regarding Laura's official United States Equestrian Federation competition history, safety logs, and incident reports. In Marraccini's motion to dismiss the DVRO, pursuant to this California code, his counsel alleged that Laura rebranded horsefall injuries as domestic violence bruises, citing competitions in February 2017. Ms. Brozick will testify that USEF's official safety records reflect no reported falls, injuries, or on site medical incidents involving Laura at any USEF sanctioned competition in 2016 or early 2017, including those cited by respondent. The only recorded equestrian related event occurred in May 2017. Okay. When Laura experienced a grand mal seizure while mounted at the walk on a horse at a USEF sanctioned competition in Petaluma, California. She fell as a result of the seizure, not a riding error or accident, and was treated and released the same day without overnight hospitalization. Does that sound normal? Wouldn't this be the first time that's ever happened? And she was just like, oh, that's it. You're done. Okay. I don't know how they work. I've never had one, and I worked with a guy that had one once at work. But other than that, I do not have any real knowledge about seizures and how they work. But I feel like if that's your first one and you fell off a horse, you might be there longer, but okay. Maybe not. Let's see. So they followed Laura by car to the hospital. USEF's mandatory reporting protocols require documentation of any ride or fall or medical transport. No such records exist for Laura at any other time in her competitive history, confirming that she has never been hospitalized for any fall reported in USEF's competition logs or in general. This neutral governing body evidence directly disproves Marraccini's claim that Laura's injuries were equestrian related and reinforces eyewitness accounts showing that her May 2017 medical emergency was the result of a seizure and not a riding accident. Okay, well, I don't think so, but that's what ChatGPT is telling you to write. It's very clear that's what you used to write this, but okay, sure. Hey Rob says it's interesting that in this century women are responsible for their own bodies. So tonight deal with their own bodies. So tonight deal with how you want to deal with your body. It's just amazing to me. Don't let anyone tell you what to do. That's very true. That is very true. So Mike didn't cause the epilepsy. Well, she's saying he did. He did, and that's why she fell off the horse. Because apparently he had just abused her a few days before. I don't know. That's what she says. I don't believe any of the shit that she's saying at all about any of these witnesses. I mean, we know a lot of it's not there. So, oh yeah, please don't forget to like the stream. Let everybody know that we're live and talking about Mike before our fundraiser. So that would be great. And if you haven't subscribed yet, please do that. Hit the notification bell so you never miss when we go live or drop an episode. She's had Wink says she's had 3 different excuses at minimum for her epilepsy, right? Oh yeah, because she says, oh, it was from Mike and his abusive choking me that I developed epilepsy. Then it was her Uber crash incident in spring of 2017 that she then says that was the reason why. And that's if any of us even believe she even has epilepsy. Personally, I don't. But how do you give someone else epilepsy? Exactly. Well, I think what she's implying is that he strangled her, depriving her brain of oxygen for so long that it made her brain bad. I don't know. I also don't know how seizures and like that works. So Uber, horse, and Mike. Oh, horse is the other one. Okay. I know. Look, it's Savage and Dave together again, like old times. Old times. I love it. Wink says, I don't believe she does. Never have. Oh, the epilepsy? Yeah, I don't think so either. I don't think so either. Let's see. Is it possible to learn this power from a Jedi? Hmm. Now, the next witness on her list is Karen Ambro Bernitis, formerly Ilmberger. Okay. An independent eyewitness. Only 20 minutes. Okay. A neutral third party eyewitness who personally observed Marraccini verbally and emotionally abuse Laura on an international flight in December 2016. Ms. Bernatis wrote contemporaneously that Marraccini was so menacing that I felt her life was at stake were she to stay with him, and slipped petitioner a note urging her to seek help. In 2023, Ms. Bernatis publicly recounted the same event in Chicken Soup for the Soul, Get Out of Your Comfort Zone, writing that the situation was so dangerous that I couldn't even risk sharing my phone number. What? Doesn't even make any sense. Her recent publication provides contemporary corroboration that an uninvolved stranger perceived Marraccini's conduct as life-threatening, supporting the continuing reasonableness of Laura's fear and the need for renewal of protection. Wait, so she got to write her own chicken soup story? This isn't the one Laura wrote. She got a whole different one? What? That's interesting. Okay. Very interesting. Whoa. It is a big ass word that I couldn't spell on my own. No, definitely not. Now, records custodians. Okay, just whomever, apparently. For Child Protective Services and Human Resource Department for, Marraccini's employer in New York. The ones that you said you hadn't contacted, but you're putting them as a witness. Okay. What does CPS have to do with anything? Expected to testify or provide certified documentation regarding two discrete factual issues raised by Marraccini in this proceeding. First, the Child Protective Services records custodian or assigned investigator is expected to confirm that a CPS report concerning Marraccini was received and investigated in 2024. What now? Do not tell me they called CPS on them and their babies. Of course she would. She's saying it's not her. I know she's about to say it's not her, but what the fuck? Shut up. Laura was not the reporting party. That was probably her mom if it wasn't her. That's just my opinion. It's just pure speculation. Just because it wasn't her that called doesn't mean she didn't have something to do with it, which I wouldn't be surprised. Oh, yeah, this is real messed up. I know Lo or someone called CPS on Mike. I want to say more than once. That's fucking disgusting. Fucking disgusting. Because listen, even if you haven't done anything wrong, I mean, CPS can come to your house for a myriad of reasons, right? There's a lot of mandated reporting and things like that. But even if you know there's no way that anything is going on at your house, your kids are taken care of, your house is nice, there is still this fear, right? That the government is coming into your house and could decide for whatever reason that they can take your babies away, just like that. And it does happen a lot. Don't get me started on CPS. It's a good idea, but there's a lot of stuff that doesn't work well. Like sometimes they'll just take babies that have no business being taken. Others, they'll leave them in abusive homes until they're fucking murdered. So you never know with CPS what's going to happen, period. So it's disgusting that anybody does that when something is not actually happening. Because nobody wants the government in their business. I know I sure as hell don't. I don't think anybody would want to. CPS guilty until proven innocent. Yeah, pretty much. Pretty much. And like, don't get me wrong, there's a bunch of shitbag parents out there abusing their kids and being horrible parents. But that's the thing is like once they're in there, you're at their whim and you're just like, oh my God, like I hope they're okay with my stuff. Like, it's not great. Yeah, it is. It's definitely a broken system. That is for sure. Laura had one of her flying monkeys do it. Was that flying monkey's name Mom? Mm-hmm. Wow. Ooh. Okay. This woman. The report's existence became public only after Marraccini and his online affiliates discussed it on Reddit, falsely accusing Laura and her family of making the report. Okay. Okay. Mm-mm. In reality, the report originated from an independent third party who found Marraccini's conduct sufficiently concerning to alert authorities. On what grounds? Ugh. The fact I feel it. I still she can tell me her family didn't do it, but I'm gonna go with they did. They did. I don't care. That's my opinion. That's my opinion. So the fact that a neutral observer viewed Marraccini's behavior as warranting a CPS report supports the inference that others, not only Laura, continue to perceive him as threatening. That's not what that means, though, Laura. Like, literally anybody can call anonymously, which you probably know that. And they have to go check it out no matter what. So it doesn't really mean anything. But okay. Marraccini's subsequent effort to weaponize and publicly mischaracterize the report further demonstrates his ongoing use of intimidation, deflection, and reputational abuse, all consistent with coercive control under the Family Code. Second, the Human Resources Department, records custodian or designated representative of, Marraccini's employer in New York, is expected to confirm that Laura has never contacted, visited, or communicated with any HR personnel, and that no record, visitor log, or correspondence supports Marraccini's claim that she made an impromptu stop to discuss the existence of the DVRO. This verification will establish that Marraccini's allegation was entirely fabricated and reflects his ongoing attempt to distort facts and portray himself as the victim. Right. Collectively, these neutral record verifications provide objective third party evidence disproving Marraccini's false claims and corroborating that his conduct continues to generate concern and fear in others. This supports renewal, blah, 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 blah. Like, she doesn't even know who to name in these. So how do you know that they would be able? I don't know. I don't like her. I don't like her. I don't care. Pam says had several calls from BioMom and had to prove innocence even though the claims were fraudulent. Yeah, there's a lot of horror stories coming out of CPS. People call all the time just because they're pissed off at somebody else or something. It's fucking stupid. And it really pisses me off. The whole system pisses me off, but I don't know. I think that she had something to do with it. In Texas, you can look at the police report to see who called for Child Protective Services. Do you have to make a police report there to call CPS? You don't hear it, so I don't know how that works in Texas. Like, you don't have to have both to call them. Anybody can just call them, which is ridiculous. Oh, yes. I don't know how I feel about that. Interesting. I'm not saying it's about. I'd have to look into how that works out. That's Does this guy work at a place that actually has visitor logs? Right? Like, I don't know, but okay. No, it's online or on the phone, but apparently it makes a police report too. Oh, okay. It is not like that here. That's very interesting. Thank you for sharing that. Now, next is Joan O'Neill, that friend that we just learned she did not rate that thing, and Alicia Justin Cook, Esquire, Cooperative Restraining Order Clinic, recanting witness and rebuttal counsel. Okay. See Miss O'Neill's admission that she wrote the statement in her declaration. Former friend of Laura, an attorney of record who handled Laura's 2018 DVRO filing through the Cooperative Restraining Order Clinic. Crock. Because this was a crock. Attorney Justin Cook will testify to the preparation and submission process. Okay. Confirming that Ms. O'Neill's declaration was independently authored and transmitted through Croc, and that Laura played no role in drafting or editing the statement. How did she submit it, though? Did she email it? Because that doesn't... Did she sign it in person? If she didn't sign it in person, no. Together, their testimony directly rebuts Marraccini's allegation of fraud in the 2018 filings, clarifies the provenance of the declaration, and establishes that any later recantation arises from personal motives, not factual error, offered solely to address credibility issues in the present proceeding. Okay. Okay. What? Number 9. Witness, Ms. Ariana Huffington. Okay. Okay. Ms. Ariana Huffington, for some reason, of the Huffington Post, is listed as a rebuttal witness, but only for 5 minutes. She's a very busy lady, so what she has to say must be so important. All right, why the fuck is she even in this? A public figure known to Laura's family through her father's professional career. Oh boy. So was Obama, but is Obama on the witness list? Oh, I hope so. Ms. Huffington will confirm that she has never met, spoken with, or interacted with Marraccini in any capacity. What? When did he ever say Ariana Huffington was involved in anything? Okay. Directly rebutting Marraccini's false public claims of association and thereby impeaching his credibility. This must have been in something that we have not read for this fundraiser, because what? Not once has she ever come up in anything. Okay. Her testimony will demonstrate Marraccini's ongoing pattern of fabrication and self-aggrandizement. Oh, that's so funny she uses that word. Like you literally started it at the beginning of this paragraph, Laura. Okay. Further undermining the reliability of his representations to the court and to public. So, okay. Okay. Because name dropping never helps. Oh, hi, Berkeley. Ron may have interviewed her. Yeah, I guess so. But like, what? What? Oh, her former husband ran for U.S. Senate in California. Oh, interesting. Dan Montana says, I think Chloe tried to get her Clayton article published in the Huffington Post. What does that to do with Marraccini? Where did this come from? Oh my gosh, it is absurd. Say cheese. Don't worry. I know I'm going to win because I have Ariana Huffington on my witness list. Which, I'm sorry, she puts these on here, and that definitely makes me question all of the other people she listed that you would probably see in a hearing, but this just, wow. Is this like her wish list? Oh, wow. Okay. Okay. Malingerer. Yes. Malingerer. She is a malingerer. That is very true. 10, the owner and operator of Instagram accounts at Justin for Clayton Official and at Victims of Laura Owens, identity unknown, to be identified via subpoena to Meta Platforms, Inc., 30 minutes total. Okay, so some Instagram accounts. Okay. Wow. expected to testify regarding the authorship, operation, and content sourcing for the Instagram accounts, which have each engaged in coordinated online harassment, defamation, and indirect contact directed at Laura in violation of the San Francisco DVRO. Laura intends to subpoena Meta Platforms Inc., good luck, girl, to identify the subscribers, registered email addresses, IP address, and device logs associated with both accounts, as well as upload metadata for the posts compiled in Exhibits 22 and 23. The operator's testimony is necessary to authenticate those records, confirm content origination, and establish that Marraccini and or his counsel provided, approved, or directly coordinated the dissemination of materials used in the post. She is always so obsessed with the internet. Please tell me that all of Reddit, everybody on Reddit is also on her witness list. She doesn't know who they are, but she's going to put them on the stand because she's got questions. Oh my goodness. All right. Where were we? The operators are expected to testify regarding how private materials, including photos, videos, and screenshots known to have been in Marraccini or his relatives' exclusive possession, were obtained and uploaded. The horror. Oh no. How Marraccini's unserved legal filings, including his CCP motion, appeared on victims of Laura Owens before Laura was served, with captions stating filings coming soon, approved by attorney, and his legal team has confirmed it, reflecting insider access and active communication with Marraccini or his counsel. For shame. Like, why does she think she can do this? Oh my God, it's so crazy. Any communications or coordination with Marraccini, his relatives, including Stephanie Marraccini, now Scallion, or representatives concerning the publication of posts targeting petitioner. Metadata or message logs establishing that Marraccini or his legal team directly uploaded, authorized, or supplied content used to harass petitioner, including court pleadings, sealed materials, and defamatory statements. All these, like, what? How's that? Okay. And the account's coordination with Marraccini's public appearances, statements, and filings, showing that posts were timed to coincide with Marraccini's interviews and legal actions. How did they do it? How did they do it? This happens to nobody on the internet, just to Laura. This testimony will authenticate Exhibits 22 and 23 and establish that Marraccini has maintained ongoing communication with the operators of both accounts, constituting indirect contact, harassment through third parties, and disturbing the peace. Okay. Even if Marraccini denies authorship, the operator's admissions, combined with subpoenaed platform data, will demonstrate that he knowingly supplied, approved, or facilitated the release of private and litigation sensitive materials. Such conduct is directly relevant to the permanent renewal of protection under the Family Code, as it shows Marraccini's continued pattern of coercive control, reputational abuse, and disregard for court orders. I mean, she literally complains about this with every single person. Oh, the internet. Somebody do something about the internet. They're passing around legal things and I don't like it. This is all private. And she's still like, somebody stop the internet. Somebody unplug it. Just stop it. Oh, poor Laura. Not. Hi, Polly. Good morning. Good morning. Hi, Sean. But did she consider Greg the hacker? I think probably that's probably why she wants to know. She's like, I know it's that's Greg. He's everywhere in all of my stuff. All right, friends. I got to take a quick break to refill on my coffee before we get into the rest of it here. So I'm going to put on a short little dance party meme video for you guys. And I will be back in just a few minutes. So go get yourself coffee, do a little dance, go to the bathroom, laugh and scream into a pillow if you want, whatever. Um, and I will be back shortly. Okay. All right. Let's do number 3. I don't think I've done 3 yet. Okay. I'll be back. All right, friends. Thank you for being patient. I now have very hot coffee. I think I put it in the microwave for too long. But we're back. I hope you enjoyed that dance party. Sorry. I was listening to it. I always forget how my whole song goes, and I love it. Okay, so well, you can't stop dancing. The rhythm just takes over. You can't help it. All right. So next on our list here is this one. Share that one. There we go. Is Laura's exhibit list. So let's see what she wants to take for her exhibits to court. Domestic violence restraining order against and renewal, both against Mike. Related protective orders against Clayton and Greg. Girl, that does not make you look good. Okay. You have this many protective orders against people. Ooh, yikes. You love that song? Aw, I love that. I'm glad you like it. You too, Dave. Aw, it puts a huge smile on your face. Aw, I love that. I love that so much. Then the declaration of Laura Owens, which we read all three of those. Yikes. Declaration of David Gingras, a video posted by Clayton showing Marraccini with Greg in Arizona one day before the Owens v. Eckert hearing, demonstrating coordinated conduct and disregard for court boundaries. Okay. A video, Marraccini present at the Arizona paternity case trial, a video with witnesses confirming Marraccini's presence during Laura's paternity hearing in Arizona, despite the San Francisco DVR's no contact. And then an article and video, an exclusive interview, second victim of Bachelor false accuser speaks out. This is when he went on with Megan Fox. Oh, that's not how you highlight that. There you go. Then YouTube video breaking Bachelor Clayton's accuser as text exposed from previous boyfriend. Is that Dave Neal? I feel like it sounds like that's him. A video with 17,000 views, spreading fabricated messages attributed to Laura, relying on leaked material traceable to Marraccini or his relatives. Everybody's always conspiring. Website and archive of victims of LauraOwens.com. Oh my goodness. Consolidated exhibit of the website's pages and posts containing over 2,000 leaked text messages, commentary, and defamatory narratives published between 2023 and 2025. Content mirrors private material in Marraccini's possession, showing direct or family-assisted dissemination of confidential communications to damage Laura's reputation. The Volo site is very resourceful and very organized, and it's all pretty much court records. So, right, Laura. Okay. Okay. I don't like how they've organized all of my lies. It makes me look bad. It needs more cowbell. I do have a cowbell around here somewhere. I think it's up over on one of my shelves. She trots out her restraining orders like they are merit badges. She does, doesn't she? She doesn't realize how bad that makes her look, quite frankly. Liz says she's like me fighting the education authority now in the healthcare system. Oh man. Okay, so the Volo site, she's okay. Respondent Marraccini's leaked video of Laura's fall. A leaked video, like it's a fucking sex tape or something. Shut up, Laura. Video uploaded online showing Laura's fall off of a horse in June 2017. This thing that happened in public where there was cameras everywhere. Footage exclusively sent to Marraccini, released to humiliate and discredit her. Marraccini knows that Laura's business is selling horses and that her reputation as a good rider is key to her doing that. Leaking this video is damaging to Laura's reputation. Right? Not the felonies you got. Nope, that had nothing to do with damaging your reputation, but okay. Hello, Tehran. Oh, I'm a Tehran. I like it. I wonder if she's in the chat right now. Maybe. That Llama, she's called me dumb. She's called me a dumb bitch. She said a lot of mean words about it. She's just trying to humiliate and embarrass me on the internet that I've already been humiliated on. Post by Sister Stephanie under the Reddit username, where she publicly identifies Marraccini as her brother, stating Mike is my younger brother and I could not be prouder of him. Oh, that's nice. And asserts after his June 28th, 2024 interview with content creator Megan Fox that he is finally allowed to speak for himself, falsely suggesting that the San Francisco restraining order is no longer in effect. I don't think that's true, but okay. Her comments further include targeted attacks against Laura and her family, such as her parents bankrupted themselves because of her lies. Is that a targeted attack when your parents are filing for bankruptcy again? And Laura's whole family is toxic. And repeated demands to take down your fraudulent TEDx talk, Laura. Literally everybody on the internet is saying all of these things. I've said all of these things pretty much. Okay. It's not a targeted attack when it's just reality, but okay. These posts demonstrates direct coordination with Marraccini and an ongoing effort by his family to harass Laura, spread defamatory claims, and misrepresent the status of the restraining order. Such conduct constitutes indirect contact and disturbing the peace and violates the continuing DVRO protections because other people have opinions. Excuse me. Oh, great. Now I got hiccups. That's always fun. Laura being Laura is damaging her own reputation, right, April? Like, girl, you haven't had a reputation in a very long time. Is the truth an attack to Laura? Yes. Yes, it is. How dare you burst her delusional bubble? She is a pretty, pretty horse princess. See, she says, my parents bankrupted themselves of my daddy's gambling, my horses, and my lies. Mm-hmm. Right? Screenshot Marraccini's leaking private photographs. Image confirming Marraccini release of private and explicit photographs of Laura, constituting a direct violation of the DVRO and continued psychological abuse. Folder, just a whole folder. Marraccini sharing private videos and videos on Discord as Honk My Meat. Honk. Screenshots and chat logs showing accounts linked to Marraccini distributing private media of Laura and her family on Discord, causing reputational and emotional harm because those people on Discord are me. Communications between Marraccini's ex-partner, Callie, and petitioner messages from Callie acknowledging Michael's volatile behavior and thanking Laura for warning her, blah, 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 blah. I'd love to see those. Why haven't you made those public, Laura? Convince the internet to be on your side. Release them all. Why not? Why not? Declaration of Karen, Napkin Lady, who also apparently was in Chicken Soup for the Soul as well. The CPS and HR records. Petitioner intends to subpoena, so she has nothing about this. Certified records from CPS and the employer in New York to verify she made no contact with either agency and that any CPS reporting regarding Marraccini was filed by an independent third party. But it's so funny that she was like, it wasn't me, it was a third party. But yet, when Mike's sister, a third party, put stuff on the internet, you're blaming Mike for that. But you're not to blame for a third party for calling CPS, right? Okay. Sure. Why not? Both confirmations will demonstrate that Marraccini falsely accused Laura of actions intended to incite harassment and deflect accountability. Oh, wow. I didn't know she knew accountability was a word. She doesn't honk meat. She batters it with her tonsils. It's called tenderizing, April. You got to tenderize it. Seichi says, did she always say that Honk My Meat was MM, or did she also say that user was Greg? I feel like Honk My Meat's Mike. Clayton was silly goose tits. And then Greg, I don't know if they mentioned the names. She just accused everybody on Reddit of being Greg. I don't know if there were any specific ones. There probably was. But yes, it doesn't matter because they're all Greg. We're all Greg. Actually, I'm Greg. I'm just wearing like a human, one of those very realistic hyper masks. So let's see. Then transcription video of the Owens Eckerd's post-trial interview with Marraccini with Megan Fox, blah, blah. We've already went over that. YouTube video, Bachelor Clayton isn't alone. Wild text revealed from victim 1 years before. Video posted by Dave Neal showing screenshots of Laura's private messages that could only have come from Marraccini or his associates. By leaking and distributing these communications publicly, Marraccini violated his DVRO. Okay, get a life. Screenshot, Marraccini comment on Instagram. Oh my goodness. Under Clayton's Eckerd's verified post, Marraccini publicly tagged at Ted and AdTech official, writing, "Enough is enough. Take down her completely fabricated TEDx talk about me. This direct incitement of harassment and reputational attack further breaches the DVR no contact and no harassment provisions." Okay. And I'll say this, that part right there goes to show you that she's not going to stop with Mike as much as possible because she needs this for her other shit, the only stuff she's ever proud of, to stay up. So Seichi says you can't just subpoena CPS records. You have to do an 827 petition. It is a convoluted process that varies county to county, and they would never release the records in a situation like this. I would think so, right? Especially since it's concerning children. Anything with juveniles is like real fucking hard to like get for good cause. But you can't tell Laura that she has power, say cheese. Good lead in. I got finger banging on my bingo card today. Boom, just waiting patiently on Llama to say it for bingo. Congratulations, Pam. You get the bingo. The finger banging bingo. Seichi says in my county, it would really routinely take 9 months to get CPS records. I could see that. I could see. Excellent point. Thank you for sharing that. That's why I wasn't taking her seriously anyway, but excellent points. Thank you. So they want the TEDx on. Then screenshot of of Marraccini calling Laura dangerous. I've called her dangerous a lot. She is dangerous. An Instagram exchange between Marraccini and Greg Gillespie, against whom Laura holds an active Arizona order of protection for. Gillespie wrote, "Stop this woman. No one should cave to her harassment. She is dangerous." Agreed. And Marraccini replied, "Dangerous is an understatement." What threatening words those are. Shut up, Laura. This public interaction constitutes indirect contact and reputational harassment, violating the DVRO. Okay. She's always wanting to silence people's free speech, isn't she? Then Joan O'Neill, who is her friend that is recanting this, apparently, includes Joan O'Neill's original signed declaration filed March 29, 2018, in support of Laura's DVRO, together with contemporaneous text messages between Ms. O'Neill and Laura. The declaration details firsthand observations of Marraccini's controlling, demeaning, and physically abusive conduct, and was transmitted to the Cooperative Restraining Order Clinic by Ms. O'Neill herself. The attached messages confirm that Ms. O'Neill's independently authored, signed, and faxed her declaration. Oh, so not in person, after all. Interesting. Quote, I just wanted to finish up the statement and have it notarized. I faxed the declaration. That doesn't mean anything, Laura. These records directly refute Marraccini's claim that Laura fabricated or drafted Miss O'Neill's statements, and they corroborated the authenticity and voluntary nature of her sworn declaration. I don't know about all that. Shut up. I thought this was a family show. Dave, it's not your first day. It is not your first day around here, sir. We've been together for over a year now. You know how it goes. It is our little dysfunctional family. Seichi says, and when we get the CPS records, the reporting party is never disclosed. You can suss it out sometimes, like school, doctor, police. Yeah, I'm sure. Because mandated reporters probably use very specific language and also probably don't include a lot of emotional language, like if it's a family calling on a family or something like that. Maybe. I don't know. Let's see. Okay. Then the Instagram account, Justice for Clayton Official. You already, okay. Compilation of select posts from the Instagram account, which has persistently targeted Laura through defamatory and harassing content that could only have originated from Marraccini or his family. The account operates as a coordinated proxy used to continue Marraccini's harassment and reputational attacks in violation of the code of the DVRO. The account routinely posts private photos, videos, and screenshots known to have been in Marraccini or his relatives' exclusive possession, including materials shared privately during the party's relationship. False, humiliating, and inflammatory statements about Laura, including that she is a serial liar. I mean, you do have 14 felony accounts for perjury and fabricating evidence. So, is it false, though? Mentally unstable and dangerous. She does not like that word, but she is. Hashtags and captions directly tied to Marraccini's public narrative, such as hashtag justice for Mike, hashtag expose Laura Owens, and hashtag Team MM. Oh, and posts published in close coordination with Marraccini's own appearances, comments, or his family's online activity, reflecting direct collaboration or shared content access. Oh my gosh, it's so scary. Defamatory equals truth. Thank you, April. Adding all the words to our Laura Owens lexicon dictionary, which will be out later this year. Just kidding. It won't be out, but at this rate, we might as well. Sky says, I'm ashamed. In Germany, every court would say no to her claims without 100% proof of her pregnancy or loss of it. But but in the US, it's playground time. I need attention. So Laura does that. Yeah, I mean, it, even as an American, the fact that all of this was allowed to go as far as it did, I think is also what's very alarming about this case. Now, we usually talk about criminal law and not civil because it's bananas. It's bananas. I don't know if I like it or not. I mean, I don't practice law, so whatever. But civil law is straight up bananas. All right. All of this delaying, all of this mucky drama, you don't really see that on the criminal court side. It's pretty like, I mean, there's drama and stuff, sure. But this is all, they don't need a lot of proof for things. And it's kind of wild to me. But then the standard bar is much lower for all of these. But yeah, I agree. I don't like this at all. Seichi says Laura is exceptional at stress testing flaws in the legal system. Agreed. Again, I mean, I can't believe Greg's and Clayton's went on for as long as it did. But hey, you know what though? It really, while it frustrates me about how much the courts allowed all this to go on, allowed these innocent men to rack up all of these bills based on her fucking lies, it did end up getting her name out there in the world to hopefully deter future victims. Do I think that's going to happen? No. But it also gave her a bunch of felony counts. So it's actually one of the few times where I think karma actually like came to fruition in the courts. Because again, you don't really get charged with those charges very often. So I was shocked, I tell you. Shocked. Now, the consistency in tone, timing, and the use of private materials from the IG account establishes that Marraccini or persons acting under his direction have actively provided this account with content, commentary, or access to personal media and information. How fucking dare they? These actions amount to knowing and willful violations of the DVRO's prohibitions on direct or indirect contact, harassment, or intimidation through third parties, and disturbing the peace. Why did you bullet point it this time but not earlier? This exhibit demonstrates Marraccini's ongoing use of third-party intermediaries to perpetuate contact, reputational harm, and emotional abuse after being ordered to cease all communications with petitioner. So basically, it's just like when she'd be like, oh, my mom saw him out in public close to my place. I never saw him, but his mere existence to her, wherever he is all of those things to her, which is just crazy. That's true. The taxpayers have paid every dime. I don't like it. She says there may have been a backlog from COVID when their cases were being heard. It took us until about 2025 to get our caseloads down. That's a fair point. That's a very fair point. I mean, Greg started in 2021 and Clayton in 2023, but you're absolutely right. I mean, the last trial I covered in January and February, the New Jersey versus Paul Canero, that crime happened in, I believe, 2018. I think it was 2018 or 2017. And that was a murder trial. And it just finally went to trial. Now, murder trials can take a long time, but COVID was one of the reasons why it got pushed and lawyers quit. It caused a very big kerfuffle in the court system. So that is a very fair and valid point, but I'm still not happy about it. I'm still not happy about it because if the case was overloaded, then I don't know. Just do away with the bullshit ones. But no, I completely understand what you're saying there. All right. So then for the IG account for victims of Laura Owens, it's the same thing. So we're gonna scroll through that. That's nothing crazy. God, who sent this in? My God, were they on drugs? All right. Voicemails from Peggy Marraccini mom to Laura. Oh. Did she even know that? Well, I guess they were voicemails. Never mind. Audio recordings of voicemail messages left by Mrs. Marraccini, Michael's mother, during a period when Laura was attempting to distance herself from Marraccini and in the relationship. What's the date on these? The messages show that Laura was not returning calls or initiating contact, while Ms. Marraccini repeatedly reached out, expressing distress and attempting to reestablish a connection. Representative excerpts include, quote, "I'm a stage 5 stalker now, but I just want to hear your voice and know you're okay. Oh, I want to see you, want to hug you, and want to kiss you. Okay. I don't know what happened, but I just want to see you. I miss you so much. Oh." Ella Feet's mom's name name is Peggy, and that's very Peggy-like of her. That's, oh. These voicemails confirm that Laura was not seeking or maintaining contact, directly contradicting Marraccini's current narrative that she was obsessed, fixated, or unable to move on. Instead, they show that it was Marraccini's family pursuing Laura after the relationship ended. Shut up. While recorded prior to 2020, even though she doesn't give the date for any of those, they remain relevant and admissible under the family code because they clarify the nature of the relationship, support Laura's credibility. I don't think so, but okay. And illustrate that her conduct since separation has been consistent with seeking distance and safety, not ongoing pursuit. Right. Right. Okay, sure. It's the same playbook that Amber Heard's trying to use. Kind of. How dare Mike exist? How dare he or his family or the internet having their own opinions? Oh, you inherited a 2017 case in 2023. Yeah. So, yeah, COVID really messed some things up for sure. Skybell says Laura would hate me because if I met her, she gets our banking. Oh, I think Laura would not like any of us because we don't believe her. So, oh well. All right. Lastly, this is the last thing we're going to read for today. Oh, it's only noon. Nice. We are making good time today. Love that. Hello, Mama Llama. Hello. Good afternoon to you. Good afternoon. Hope you're doing well. All right. So this is filed by Laura. This is her motion in limine, where she wants to exclude witnesses from Mike's list. And she gives reasons why. So let's find out why she thinks these witnesses should not be allowed to testify. First up, she wants to exclude Greg Woodnick. I wonder why that is. Why would she ever want to do that? Dave, do we have a trial to watch in the works by chance? Actually, we do. We have, after we're done with this fundraiser on Saturday for Mike Marraccini, which if you don't know about, Saturday from 12 p.m. to 12 a.m., hosting a 12-hour mega fundraiser for Mike Marraccini because he's still battling this biatch. So we're raising money for him there. It's going to be a lot of fun. But after that, we'll be going back to the Clayton Ecker story because we put a pause on that. And then so we have that trial to watch. And then we'll find out on the 26th or 29th of whether or not she's taking her felony plea deal. If she doesn't, then we're looking at a potential trial at the end of July, beginning of August, which, in my opinion, based on everything we know about her, if she says no to the plea deal, which would be stupid, but also here we are. But I do think she'll find a way to delay the trial, even though she hasn't waived her speedy rights. I have a feeling she'll be like, oh, my private lawyer, I had to fire him. I need a new lawyer. I mean, it checks out. Is she a chaotic tornado all the time? Yes, but she does have patterns to her chaos, and I think that's what she's going to try to pull. She would like you. You think you can fix her, Savage? I can fix her. So yeah, there will be things. Plus, there's like bankruptcy hearings. I don't know if Hey Rob's still here, but there was an injunction against. There's lots. We still have several months of coverage to do on this story. So lots of things, all of the things. All right, let's see why she doesn't want Mr. Woodnick to be in here. Mr. Woodnick is thus offered not as a percipient witness, but as an expert to give personal opinions about Laura's credibility and mental state, topics that are inadmissible under California evidence law. I mean, mental state, I would agree. I would think. Just because I've seen in trials where they try to get somebody to say that and they're like, objection, not qualified. They are not a mental health professional, blah, 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 blah. So, okay. But dealing with her, why not? Lack of personal knowledge and relevance. Oh, I don't know about that. Mr. Woodnick has no personal knowledge of Laura's relationship with respondent Marraccini. What? We know that's not true. We saw of Clayton's legal bills where they were very much contacting Marraccini and getting his story. So, okay. His only involvement with Laura arose while he represented other clients in Arizona. Those unrelated proceedings have no bearing on whether Laura continues to harbor a reasonable apprehension of future abuse from Marraccini as required by code. Testimony lacking firsthand knowledge is inadmissible and irrelevant. I don't know if I would say it's irrelevant, but okay. C, bias, hostility, and retaliatory motive. Oh, okay. Let's see if she's going to mention Hoboken. Do we think she's going to mention Hoboken? Maybe. Oh, savage. When I said, can you fix her? He goes, no, not into full restoration jobs. All right. So the record establishes an extraordinary conflict of interest. Okay. According to the court-generated email chain dated August 1st, 2022, Exhibit 4, Laura reported to the Maricopa County Superior Court, oh, here we go, yep, called it, that she had been assaulted and had strong reasons to believe that both the defendant, this would be Greg Gillespie, and his counsel, Greg Woodnick, were involved, and that there was a pending FBI investigation. Oh, this bitch. She wrote that to a judge. She accused those two of setting her up to get sexually assaulted by some random dude in Hoboken and live stream it on the dark web, and that the FBI was investigating. That was ridiculous. I remember when we read that. We were just like, what? What are you saying? But never went to the police, just straight to the FBI, of course. The court's judicial assistant forwarded that message to Mr. Woodnick and reminded Laura that ex parte communication was not permitted. From that moment, Mr. Woodnick became aware that Laura had personally accused him of serious misconduct. Why would he be upset about that, Laura? Why would that even happen? I thought that was my phone vibrating, but my phone's not even out here. Oh, weird. Since that disclosure, his actions towards Laura have reflected sustained hostility. He has described Laura publicly as someone who fabricates abuse allegations and suffers from unreasonable fear. On March 7th, 2024, while representing a different adverse party, he issued a Woodnick Law PLLC press release repeating those phrases and asserting that Laura had falsified evidence. Statements made months before any evidentiary hearing or ruling in the Arizona matter. But girl, you got 7 charges doing just that, for exactly that. So, okay. He didn't lie because that's what you got charges for. Exactly those things. Oh my God. Okay. Okay. Laura later filed a State Bar of Arizona complaint documenting that press activity and other unprofessional conduct. She actually sent him bar complaints, like 3 times, I think? Documenting that press activity and other unprofessional conduct. Although the bar closed the file without formal discipline, the existence of the complaint demonstrates that Mr. Woodnick's professional conduct was formally challenged by this petitioner, me, Laura Owens. Like, that doesn't mean anything. I can write one right now if I want to. It means literally nothing, but okay. Having been personally accused of abuse and professionally reported for misconduct, Mr. Woodnick now seeks to testify as an expert that Laura fabricates abuse allegations. That sequence creates a textbook retaliatory motive under this evidence code, a desire to vindicate himself by discrediting the complaint. Okay. Such bias renders him incapable of neutrality. Sure. Right. Okay. Under the family code, the court may exclude testimony that would cause harassment or intimidation of a protected party. And under evidence code, it may exclude evidence whose probative value is outweighed by the danger of undue prejudice. Mr. Woodnick's participation meets both standards. I'm going to disagree with it, but okay. That's right, Sage. She is once again advancing a truth narrative in response to her lies is deemed as harassing. Like, she does not like it. She does not like it. Improper expert and character testimony. Mr. Woodnick's proposed opinions that Laura fabricates abuse allegations or acts from unreasonable fear concern credibility and emotional state, not any field of technical expertise. Such opinions are barred by the evidence code and constitute impermissible character evidence. Admitting those opinions would usurp the court's role as fact finder. Okay. Mischaracterization of Arizona proceedings. Oh, okay. So why are we all wrong? This is not how it went down in Arizona, but okay. Marraccini's disclosure asserts that Mr. Woodnick will corroborate findings in Arizona paternity litigation. This representation is incorrect. Okay, how? Why? The Arizona case contained no judicial findings that Laura fabricated abuse allegations or lacked reasonable fear. Oh my goodness. Wasn't there the domestic violence protection order you asked for Clayton for the picture on Reddit? And then Greg, you kind of did though, didn't you? Mm. Any claim to the contrary is a misstatement of the record and should be barred as misleading. As the Court of Appeal held in Ritchie versus Conrad, a renewal hearing is not a retrial of the original abuse allegations. Introducing foreign, unadjudicated narratives would violate the rule and frustrate the purpose of the Domestic Violence Prevention Act. Okay, but this was made on fraud, which we did discuss, kind of overrides that, I thought, but okay. F, unfair prejudice and confusion. She does not want Woodnick saying shit. Permitting Mr. Woodnick to testify would transform this renewal hearing into a collateral trial on Arizona disputes, disciplinary filings, and press publications. The minimal probative value of such testimony is far outweighed by the danger of unfair prejudice, confusion of issues, and harassment of the protected party. The court should therefore exercise its discretion to exclude him entirely. Well, that would be very convenient for you, wouldn't it, Laura? G, procedural improprieties in subpoena issued to Mr. Woodnick. On October 3rd, 2025, Respondents' Counsel Omar Rule Serrato issued a purported trial subpoena to Mr. Woodnick, commanding his appearance at the San Francisco Superior Court hearing on October 21st, 2025. The subpoena is procedurally defective and unenforceable for multiple reasons. Oh, okay. Why? Because I don't want him there. That's why. Hi, no thanks, MK. How are you doing today, babe? Hope you're doing well. Let's see. First, the subpoena seeks to compel the attendance of an out-of-state witness residing in Phoenix, Arizona. California subpoenas have no extraterritorial effect and cannot compel the attendance of a non-resident without compliance with the Uniform Interstate Depositions and Discovery Act. Okay. No such domestication proceedings have been initiated in Arizona, and therefore the subpoena has no legal force outside of California. But, like, what if somebody moves to a different? That doesn't make any sense. There has been other trials. There was one in Wisconsin, I remember one time. I can't remember what it was. It happened in Wisconsin. They had family or people in Texas. They had to subpoena people from Texas because it was a whole kerfuffle for some reason. So, like, I don't understand that argument, but okay. Second, the form shows no clerk's issuance or court. I mean, she was going to subpoena people in New York for his company in New York, but she's like, no, you can't subpoena anybody. Okay. Second, the form shows no clerk's issuance or court seal, only the handwritten signature of Mr. Serrato. A subpoena for trial testimony must be issued either by the court clerk or by an attorney as an officer of the court, only for witnesses within California's jurisdiction. Because Mr. Woodnick is out of state, Mr. Serrato lacked authority to use it. Did she just like not see a copy? That'd be like a weird thing he would get wrong, I think. Third, there is no proof of witness fee tender or proper service. The code requires that statutory witness fees and mileage be paid or tendered at the time of service. The subpoena file contains no such proof. Okay, nor is there any executed proof of service establishing personal service within the jurisdiction. Oh, you're just throwing all of the things. Fourth, even if procedurally valid, the subpoena seeks testimony that is irrelevant, cumulative, and harassing in a family code renewal hearing. Mr. Woodnick's proposed opinions pertain to unrelated Arizona matters and to Laura's supposed credibility, topics far outside the narrow statutory inquiry. The court should quash or disregard any subpoena that would impose undue burden or intimidation on a protected party. For these reasons, the October 3rd, 2025 subpoena issued and signed by Mr. Serrato is jurisdictionally invalid and substantially improper. Laura respectfully requests that the court quash the subpoena and preclude any testimony by Greg Woodnick in its entirety, because it's not going to be good for me, Your Honor. It's going to see mean things, but I am doing well as possible. Annoyed about a lot of things, but better than last week, so I guess I'll take it. I'd rather just be annoyed at people than be super duper sad all week. So, all right, section 2. She wants to exclude witness number 4, John Berryhill, the digital forensic expert. Okay. I imagine she really wants this guy out of there. Like, no, I don't want to hear what he has to say. It makes me look very bad. Reason A, identification and stated purpose of testimony. Marraccini seeks to call a privately retained digital forensic witness, Mr. Berryhill, to introduce a 2024 report and text messages from 2016 and through 2017. Materials never filed in this case and unrelated to the records supporting either the 2018 restraining order or its 2020 renewal. No forensic examination of Laura's filings has ever been done by this court. The proposed testimony is unfounded, irrelevant, and inadmissible. I don't know about that, but sure, I guess. What? No, that doesn't make any sense. Hello, Bill. How are you doing? Happy to see you here, babes. Hope you're having a good day. Seichi says this was 100% written by Gingras. There's it's written by Gingras when you see how much like case law and codes are inserted in here, because she doesn't know any of that. But I agree with you. I think she had a lot of help with this one. Now, let's see. B, improper introduction of new exhibits and never in the record. Okay. Marraccini's 2025 executed exhibit list identifies new exhibits. Item 107, the digital forensic report by John Berryhill, and items 114 through 118, text messages from 2016 and 2017. These materials were never part of the 2018 evidentiary record that established the restraining order, nor of the 2020 renewal record. Introducing them now attempts to reopen and retry matters conclusively determined years ago, based on this case and code, that evidence that was never admitted or considered previously is outside the permissible scope of this proceeding and it must be excluded. Remember, Omar is arguing that this is extrinsic fraud after the fact, and that then you can re-argue the previous cases when you believe fraud has occurred. and that there's really no quite timeline on that. All right. So, okay. C. No such documents exist in the 2018 or 2020 record. Okay, I thought he just meant in general. Like, these aren't real. Like, what? Hi, Hellville. So nice to see you. Oh, thank you. I know you're going to a festival, which I'm so excited for you. But thank you. That's so kind of you to say. Is it in the pleading? Does the text line up? I don't know what you mean, what you're referring to. Say cheese. I'm sorry. I got distracted. Let's see. Where was I? Okay, so the court. C. No such documents exist in the 2018 or 2020 record. The court files supporting the 2018 order and 2020 renewal in Owens v. Marraccini contain no medical records, no ultrasound records, and no comparable exhibits, let alone anything falsified or misleading. Okay. Because they were on the computer. But okay. Neither party nor the court ever referenced or relied upon such material. Mr. Berryhill's testimony that Laura filed falsified medical letters and ultrasound images is therefore baseless. Testimony predicated on documents that never existed in this record is speculative and irrelevant. But wait, didn't she put these in her filing to renew this? Those doctor letters? I'm pretty sure. Oh, I don't remember. Oh, pleading paper has numbers on the side. Oh, this does not have any numbers on the side. Nope. It looks just, I don't think so. Yep, nope. This is just this. Jinger's superpower is that he knows how to format the text to line up with the numbers. That's true. I do like that. I very much enjoy that. Because there are many times where, I'll be honest, wouldn't it? Not making things line up, everything looking like grave rubbings. It's very irritating for a long time. And I will give credit where credit is due. I very much did enjoy David's laying things out. I appreciated how he did a lot of that. So there's my credit for him. Now, what they say is different, but I did appreciate it. Virtual Jara says, I have to go back to the Papas and I don't have my personal laptop up right now. She cut and pasted it. Oh, yeah, definitely. He's like, don't put the numbers. They'll definitely know it's me, though I feel like that's something super dumb she would do. So, I'm a little surprised. Let's see. D, no court authorized or neutral forensic review. The court has never ordered any forensic examination of Laura's filings or devices and has not appointed any neutral expert under the evidence code. Mr. Berryhill's work was privately commissioned by Marraccini's counsel, conduct without notice to Laura, and performed outside any judicial supervision. What? They do this all the time. I don't understand. A privately retained analyst cannot be presented as a neutral forensic review. They literally do that all the time with experts. You hire your own expert. Okay. And admitting his report would mislead the court into believing that an official determination of fabrication exists when it does not. Testimony lacking neutrality or court authorization fails to satisfy the reliability and fairness standards of this code and should be excluded. Okay. E, absence of methodology or validation. The Digital Forensic Report, Exhibit 107, identifies no software, extraction method, imaging log, hash value, or validation procedure. It provides no chain of custody documentation, device identifiers, or metadata establishing authenticity. I feel like it does, but we've only seen little blurps. But I don't really know, to be honest here. It merely reproduces fragments of text messages without explaining how or from where they originated. Expert testimony based on undisclosed or unverified methods fails the reliability requirement for this and does not satisfy the authentication mandates. Okay. Hi, Violet. Look at who's here. Hi. They offered to let Gingras and Laura look at the computer extraction. Yeah, I believe they bring. We had finished. We paused on Owens v. Clayton right at this point where Gingras and Laura are fighting for Mike and Greg not to be involved at the trial, and became aware of this, report, and that they wanted it thrown out for Clayton's trial. And that's where I believe we paused before we shifted over to Mike, and that's where we'll pick up. So I am very interested to see, and I thought they offered them to look at it or something, but it's been a while. All right. Let's see. Irrelevance and temporal remoteness. All data Mr. Berryhill reviewed originated from respondent Marraccini's device and dates from 2016 through 2018, 7 to 9 years before this hearing. Those communications predate the incidents that led to issuing of the restraining order and have no bearing on Laura's present apprehension of future abuse. If they're from 2016 to 2018, how does that predate the incidences that led us here? I don't understand. Okay. Those communications predate. Oh, I already read that. My apologies. Okay. G, improper credibility and character testimony. Oh. Mr. Berryhill's stated purpose, confirming that multiple documents were fabricated or altered, is a direct attack on Laura's credibility. A direct attack, you guys. She does not like it. California law forbids expert or lay witnesses from testifying that another witness is dishonest. I think they can when it's about fraud, though. That makes no sense. But okay. Well, and I mean, you can't. So California law forbids expert or late witnesses from testifying that another witness is dishonest. Then what about investigators and stuff like that? It doesn't make any sense. Okay. Because credibility is for the court alone, such opinions are inadmissible. Okay. Prejudice and confusion. Allowing testimony about an unsupervised partisan forensic report in decade-old text messages would convert a limited renewal hearing into a collateral trial on unrelated issues. The probative value of this evidence is non-existent. Get out of here. The danger of unfair prejudice and confusion is extreme, and the court should exercise its discretion to exclude it entirely. Okay. Okay, sure. Why not? No thanks MK says this is supposed to be new violations only, I think. Oh, for this DVRO? Yes, but then also Omar was arguing that when there's, I believe this is what happened yesterday. My brain's still only at like 60%. Okay, so I'm taking stuff in. But he said that this qualifies as like extrinsic fraud going on here all the way back to 2018. And therefore, his argument is that they should be able to have a hearing about all of this because there is no statute of limitations. He used a different word, but that kind of idea in a case of extrinsic fraud. So now whether that's true or not, I don't know. I'm not a lawyer, but right. They're supposed to be getting their own expert, but never did. I wonder why. I know. Say Cheese says Omar was trying to undo the original order on the basis of fraud. Yes. So not only was he arguing not to have this continued for 2025, but one, that they should go back and take away from the 2018 one all the way back because it was on fraud. Also recommended that the judge send her info to the district attorney for some possible criminal charges. So That's interesting. Let's see. All right. Then she wants to exclude witness number 5, Gregory Gillespie. Wonder why. I wonder why. Oh, my goodness. Oh, you were just explaining what Gingy and Laura meant about, the dates. Oh, okay. No, still. That's fine. They're doing their best because I wonder, do you think Gingras talked her out of renewing this? And she was like, no, I'm going to do it anyway. Or did he encourage? I mean, because this is, why would you want to go back to court anywhere while you currently in the timeline have 7 felony counts? That seems crazy. Oh, that's right. The criminal charges were recommendation were based on witness intimidation of Mike. That's true. When you watch Jack Frost, Jack Fox, and use the word just, Jack is going to be on our fundraiser on Saturday. I am very excited to talk to him about things. I watched a few of his videos and I was like, oh, that is very interesting. He talks about words and analyzes words. So I don't know if I want him analyzing me, but no, I'm very, very excited to talk to him on Saturday. It's going to be great. So Gingras was giving her really bad advice. Criminal exposure. That's true. It's true. Bill says Gingras was encouraging and trying to stay involved because Mike filed a bar complaint against him and DG wanted to discredit him. Oh, that's a fair point. And they're arguing this whole time of whether or not he can represent Laura in this case. That's true. That's all fair. All fair points. Okay. So here's why she doesn't want Greg. Marraccini proposes to call Mr. Gillespie to repeat discredited allegations from Arizona litigation case that were resolved entirely on procedural grounds and never adjudicated as true. Okay. So all right, fine. No court has ever found the petitioner falsified a pregnancy, submitted a forged ultrasound, or misused protection orders. Well, not yet, babes. That's what you got some charges for. They haven't found it yet, but okay. Though I feel like Judge Mata did say that. It wasn't just in her recommendation to the district. She says those things, but we haven't even gotten there yet, so I don't know. Such testimony would be irrelevant, misleading, and unduly prejudicial. But I want to bring in all of my restraining orders on these guys, but I don't want them to come in and talk about it on the stand because it would make me look bad. Irrelevant to renewal under Family Code. A hearing on renewal is not a retrial of the original abuse allegations. The inquiry is limited to whether the protected party entertains a reasonable apprehension of future abuse, which I believe is a bunch of bullshit. We just talked about this, but also when Mike goes for his 2020 hearing, this was the grounds for getting a 5-year one. It's just her being like, I'm really scared of him. And I think that he is just never going to leave me alone. So I need this for 5 years. And that was pretty much it. And Mike's like, what? No, like, I don't want to, I want to fight this. Right. And the judge is like, sorry, that day was today and you don't have anybody. And she says she's scared. So 5 years it is. Boom. What? I did not care for that at all. Allegations concerning a separate Arizona civil case have no bearing on whether Laura continues to fear Mr. Marraccini. Such testimony is irrelevant and inadmissible. Phil says that was the basis for DG's conflict of interest. He was a witness related to the claim regarding Mike's appearance in AZ. That's true, yes. Violet says DG said very clearly that he wanted Mike to testify so that he could extract some sort of information to help his bar case. Oh, interesting. I know there's like so many blog posts of his we still have to read and stuff. Kind of excited to get back to that craziness. Sage Cheese says, by the way, when she is convicted on this, I love when you say when she is, because she will be, she will appeal and then claim that the finding she committed fraud is not fully adjudicated. Oh, she's going to appeal everything. Well, but see, that's another reason I don't think she's going to take the plea deal. It's because if you do, you don't get to appeal shit. And we all know she loves to appeal literally everything. She has yet not to file an appeal based on any of the court stuff we've covered. So I still feel like we're going to trial, guys. I don't think the trial is going to be in August or July. People appeal pleas? I thought you weren't allowed. No? Or is that just a stipulation they can put in there? Which is it? Oh, that's interesting. Tell us more. Half-ass fashion. Hey, babes. And if she pleads guilty, she won't be able to continue to torture these men. That's true. But if somebody else finds her guilty, then she can still play her victim card. It is her only way of feeling appealing. Oh, that's interesting. Okay. All right. C, no adjudicated findings of fabrication or fraud. The Arizona record affirmatively shows the absence of any finding that petitioner falsified a pregnancy, forged documents, or abused the protective order process. What date was this? This was filed on 10/16/2025. So about a month before she gets 7 more charges for Greg Gillespie for perjury, fraud, tampering with evidence, all of that. So it's kind of funny. Oh, okay. So Seichi says the DA can put in a condition that she waives appeal rights. It is pretty rare to do this. See, I did not know. I thought that was just blanket always. But, and the reason I wondered, or I was like, oh, maybe it's just something they have to put in there, is because that was part of Brian Kohberger's plea deal, is to drop ability for all appeals, point blank, period. So then I was like, oh, maybe it is just a specific language. Because I guess that'd probably be against some constitutional rights or something, huh? I imagine it's hard to get an appeal, though, if you plead guilty. But look at us learning things. I love how we all learn things together. It's fantastic. You guys are very knowledgeable. All right. So C, no adjudicated findings. I already read that. I'm sorry. In Owens v. Gillespie, the defendant's own second supplemental rule disclosure statement filed by Greg Widnick merely alleged that Laura reportedly fabricated a pregnancy and subsequent abortion, but cited no supporting evidence. I don't know about that. Laura's motion for partial summary judgment established that Gillespie did not suffer a consequent proximate injury, did not incur damages, and did not suffer severe emotional distress. Don't even get me started on how that one ended. It pisses me off. 3, the minute entry of November 9th, 2023 from Honorable Michael D. Gordon, who couldn't be fucking bothered to listen to anything, granted both parties cross motions for summary judgment, expressly finding that the damage disclosure made by Gillespie with respect to the fraud are insufficient for both claims. Those rulings dispose of Gillespie's fraud and emotional distress counterclaims solely for lack of proof, not because Laura fabricated evidence. Okay. No Arizona court has ever entered a finding of perjury, forgery, or false pregnancy. Oh, Laura. Oh, it's like she prophesizes her own future, but doesn't realize that she's doing it. And I love that. Oh, bye, Dave. I hope you have a great day. So happy to see you. Don't be a stranger and be safe riding your motorcycle. All right, safety first. Bill says it depends on the plea. They can even agree to specific appeal rights to waive, but not all of them. I did not know that. Oh, that's just Pam being so kind. Hope everybody's having a good day. All right. Where were we? Protective order remains in effect. Laura currently holds an active protective order against Mr. Gillespie and previously obtained uncontested orders. None have been vacated or denied. His testimony that Laura misused protection orders is contradicted by those undisputed judicial records and should be excluded as false and prejudicial. Okay. They're all dumb. E. Misrepresentation and potential to mislead the court. Permitting testimony that Laura's faked a pregnancy, forged an ultrasound, or misused protection orders would misinterpret the Arizona proceedings and mislead this court into believing such findings exist. Evidence code authorizes exclusion of evidence likely to mislead the jury or cause undue prejudice. The court should exercise that direct discretion here. F, lack of personal knowledge. Mr. Gillespie lacks personal knowledge of any facts relevant to Laura's present relationship with Marraccini or to her reasonable apprehension of future abuse. Testimony must be based on personal knowledge. His proposed testimony concerns unrelated, closed Arizona matters and is therefore inadmissible. G, bias and retaliatory motive. Mr. Gillespie remains the opposing party in multiple Arizona protective order proceedings that petitioner Laura lawfully obtained. Having been the subject of those orders, he possesses an obvious motive to discredit Laura. This retaliatory interest falls squarely within the evidence code. H, unfair prejudice and confusion. I gotta move something real quick. Okay. Okay, where was I here? Right tab there. Okay, sorry about that. I got a little distracted. Unfair prejudice and confusion. I already read that. Oh, no, I didn't. Introducing Arizona's allegations of false pregnancy or forged ultrasound would confuse and prejudice these proceedings by suggesting petitioner engaged in conduct never proven or adjudicated. Any minimal probative value is vastly outweighed by the danger of undue prejudice and confusion. All right, so they don't want Greg Gillespie there either. She's like, no, these people are all so bad for me. What could they possibly say that's relevant? Then they want to exclude witness Terry Bowe, the Maricopa County investigator. Okay. Identification and stated purpose of testimony. Detective Terry Bowe is a law enforcement investigator from Arizona who seeks to testify about an ongoing criminal case in which Laura has been indicted but not convicted. True. The subpoena served on Mr. Bowe is procedurally void, and the subject matter of his proposed testimony is inadmissible under the California Evidence Code. Okay. Well, hi, Jupiter. So nice to see you. Hope you're doing well today, babe. Hope you're having a good old Tuesday. We're here doing the thing, reading all this ridiculousness. All right, B. Unsigned and invalid subpoena. The subpoena form attached to Marraccini's notice of subpoena, replied Terry Bowe, contains no signature or date of issuance on the attorney's signature line. Oh, yeah, this is definitely written by Jingris. Under the code, a subpoena must be signed by the clerk, blah, blah, blah. She already said this about somebody else. Out-of-state witness beyond California jurisdiction. Mr. Bowe is employed with Maricopa County and resides outside California. California subpoenas have no extraterritorial effect. This court lacks jurisdiction to compel an out-of-state witness to appear or testify, but they still could just show up, right? No UIDDA petition has been filed or granted. Even if the subpoena were signed, it would be unenforceable. Okay, but he could still show up. I mean, right? I would think so. The notice of subpoena issuance, dated October 6, 2025, merely announces an intent to issue subpoenas and provides no proof of service on Laura or on Mr. Bowe. This requires written notice identifying the witness, materials sought, and date of compliance. Failure to provide timely, proper notice renders the subpoena defective and subject to quashal. Quashal. I didn't know quashal was a word. Oh, I'm so glad you guys had a lovely little vacation. It's so cute. I love love. So I'm so happy for you guys. You guys are so cute. Indictment and ongoing criminal investigation are not admissible evidence. Mr. Bowe's proposed testimony concerns on an ongoing Arizona criminal case that remains at the indictment stage. An indictment is not evidence of guilt, true. It is merely an accusation, but I'm pretty sure that Judge Mata ends up saying, like, literally, you've lied. And here's all the things, and I'm going to find that here and then also send this to there. But okay, I don't know. Again, we haven't read it. Allowing an investigator to describe findings from a pending case would violate the presumption of innocence and invite prejudice. California courts bar testimony or exhibits referencing unadjudicated criminal charges because they risk confusing issues and undermining fairness. Okay, I can see how that can be problematic. But people also testify to this stuff when the when the trial's happening. So, I mean, okay. You too. No, thanks, okay, right? I love love for other people. I love, love, love. Bill says that was Gingras' identical argument as to Mike's subpoena in Arizona. That's how you know he wrote this. Excellent point. Excellent point. F, improper opinion on credibility. Mr. Bowe's stated purpose to explain the investigative findings showing a deliberate pattern of deception relevant to credibility constitutes an impermissible expert or lay opinion on a party's veracity. California law forbids witnesses, including law enforcement officers, from testifying that another witness or party is lying. Such testimony evades the fact finder's rule and is barred. G, extreme prejudice and irrelevance under Family Code. Well, okay. The limited inquiry under the Family Code is whether Laura entertains a reasonable apprehension of future abuse. Criminal allegations from another jurisdiction have no bearing on that question. I disagree, but okay. Introducing testimony about a pending Arizona indictment would mislead and prejudice this court, transforming a protective order renewal into a collateral trial on unproven criminal charges. The court should exclude the evidence as unfairly prejudicial, confusing, and harassing. Okay. Then she wants to exclude Clayton. She's like, nobody can be here. The investigator would only testify as to his findings, reviewing documents and interviews he did. And that includes Marraccini's timeline, right? Because lots of Marraccini's stuff is in Clayton's investigative report, if I recall. Greg's has not been released yet, but there was surprisingly quite a bit of Marraccini info in there, if I remember. I love Lamp. I love a horse. Do you watch Real Housewives of Rhode Island? Because Alicia's my favorite, and she's just always like, I love and so I love a cracker, or I love a horse. It's my new thing. Nobody gets it yet. It's too new, but I love it. Half-Ass says, it's funny how reasonable this all sounds, seeing as how unreasonable LO is, right? It's interesting. Hello, Soldada. I think that was right. Let's see. All right, Clayton Eckerd. So, Marraccini proposes to call Mr. Eckerd to impeach Laura's credibility based on a prior Arizona paternity and protective order matter. That case involved different facts, parties and legal issues. It contains no finding of false abuse allegations, and it bears no relation to whether Laura continues to fear Marraccini. The testimony should therefore be excluded under that code. But with him and Greg, she has these protective orders for a period of time. Even if they didn't talk about all the other stuff, I would think that them having them, they'd be able to talk about it. But okay. You fell out of love with Real Housewives? No, thanks. Okay. I just got into them, so it's fine. Just this year, I went down that rabbit hole, and I have no regrets so far. No regrets. Procedural background and status of Arizona orders. On October 6, 2023, Laura filed Owens v. Eckerd seeking paternity determination and an order of protection. The protective order was issued the same day, and after an evidentiary hearing on October 25th, was affirmed. Mr. Eckerd moved to dismiss and quash the order again, and the Arizona Superior Court denied his motion on June 18th, 2024. Well, we haven't gotten to that yet. The order remains in effect and has never been vacated or reversed, which, quite frankly, is a bunch of fucking bullshit. Because I did not appreciate Judge Judy's handling of any of that, quite frankly. No Arizona ruling has ever found that Laura fabricated or falsified abuse allegations, and no court has deemed her fear unreasonable. The continuing validity of the order directly contradicts the witness list claims that she made false abuse claims. Ugh. It's infuriating because you do see all the times the court has let her go so long that she uses it for her arguments, and it pisses me off a lot because Judge Judy, we watched that hearing. It was a load of bullshit is what it was. Shouldn't have happened in the first place, but anyway. No identical patterns and no relevance to this proceeding. Marraccini's assertion that Mr. Eckerd's case shows identical behavioral patterns is factually and legally baseless. Laura has filed no paternity or protective order case against Marraccini. Isn't that why we're here? For a protective order against, isn't that why we're here? Okay. The Arizona case concerned a separate relationship unrelated to this one. Laura never alleged that Mr. Eckerd engaged in physical violence, whereas her allegations against Marraccini do. Right. Okay. She talked about how scared she was all the time. So, okay. Irrelevance to a renewal hearing. We already read that. We're not going to read that again. Lack of personal knowledge. Mr. Eckerd has no firsthand knowledge of Laura's relationship with Marraccini and did not meet him until 2024. His proposed statements therefore fail the personal knowledge requirement of the evidence code. Bias and retaliatory motives. Every time she puts that, the only reason she's filing this is literally for retaliation. But okay. Mr. Eckerd remains the respondent in an active Arizona protective order and has twice sought unsuccessfully to have it dissolved. That adversarial posture gives him an obvious motive to discredit Laura and vindicate himself. Such bias and self-interest fall squarely within the evidence code. Improper character evidence. Assertions that Laura exhibits identical behavioral patterns, false claims, or lack of genuine fear are inadmissible character evidence under this code. These opinions on credibility usurp the court's fact-finding function. She just really copied and pasted a lot of things. She's like, let's put all of these for everybody. The subpoena purporting to compel Mr. Eckerd's appearance is jurisdictionally void and procedurally defective on its face. The document is unsigned and omits the issuing attorney's required in identifying information. Okay, so that's that. Moreover, Mr. Eckerd resides in the state of Arizona, so they're going to make that whole argument. You can't subpoena somebody out of Arizona. And yes, we've read all of that several times. Why are we excluding Greg again? Section 6, you already did this, Laura. But again, she was like, you know what? I'm not done. If I put it twice, they're really going to exclude him. Okay. She's stating that the Arizona Superior Court never made any finding that Laura fabricated pregnancy or abuse allegations in 2021 with Greg Gillespie. These claims were raised only in Mr. Gillespie's pleadings and were disposed of on procedural grounds. Laura's 3 uncontested protective orders, each entered on finding of reasonable cause to believe Mr. Gillespie may commit domestic violence, directly contradict the assertion of false abuse allegations. I don't know about that. There's the renewal hearing code again that Arizona didn't find false pregnancy. This is literally the same thing. She has a protective order with him. He doesn't even know Mike. He doesn't even go here, apparently. Then, Mr. Gillespie's credibility is fatally compromised by his extensive adversarial history with Laura. For more than 2 years, he litigated against her in Owens v. Gillespie, advancing the same false pregnancy and forged ultrasound theories that the Arizona court ultimately dismissed for lack of proof. It's interesting, though, she doesn't say that the case was for abortion coercion. She doesn't mention that it also involved her being pregnant. So, interesting. That prolonged and acrimonious litigation, coupled with his repeated attempts to attack Laura's character, demonstrates a continuing personal animus. He's been subject to 3 uncontested protective orders. One still remains in effect, blah, 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 blah. Improper character evidence. Again, saying that she's a liar, but okay. Unfair prejudice and confusion if he shows up. I don't think that's really a thing, but in this case. Requested order. Laura requests the court to exclude in its entirety any testimony, declaration, or appearance by Greg. And to preclude Marraccini and his counsel from referring to any alleged false pregnancies, forged ultrasound, or misuse of protection orders. Don't ever bring that up. No. Or anything misrepresenting the Arizona proceedings, and then grant other relief. Okay. So next is to exclude, it's blacked out, but it says Ms. Joan O'Neill, to repudiate a sworn declaration filed 7 years ago and to assert that the 2018 order was obtained by fraud. Such evidence is legally irrelevant to renewal and must be excluded. Well, if you're like, oh, but it's stuff that has to be brought up then, this was brought up then. So, okay. She has the twin gene. She can't help it, guys. Hi, Deb. How are you today? So happy to see you here. Yes, there is a ton of redundancy throughout her filings and correspondence. Yes, a lot of copying and pasting all over the place. There's the renewal hearing, blah, 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 blah. Because O'Neill's testimony concerns authorship of a 2018 declaration, not current risk, her evidence is irrelevant and must be excluded. I disagree. On March 29, 2018, O'Neill filed and signed a declaration in support of Laura. The declaration bears her handwritten signature and the Gerard, I declare under penalty of perjury that the foregoing is true and correct. Well, Laura, it doesn't mean anything to you, clearly. You've said that a lot, and it didn't seem to be a deterrent. So, interesting. And then these are all blacked out for some reason. But okay, that's fine. That's fine. And then to exclude irrelevant and improper exhibits. She does not want the advisement ruling from Judge Mata in there. at all, as the out-of-state minute entry is unrelated to litigation, contains no findings regarding Laura's relationship with Marraccini or her present apprehension of abuse. Admission would mislead the court and improperly expand this hearing beyond the scope. Exhibit 2, what is this? Her criminal indictment. She does not want this to come in. That's for sure. An indictment is an accusation only and has no evidentiary value. It is unrelated to this renewal and would cause undue prejudice and confusion. I don't know about that. The correspondence with Dr. Chan, purported medical correspondence predating the restraining order by 2 years, not part of the court record. The document is remote, unauthenticated, and irrelevant to Laura's current apprehension of abuse, right? Okay. But I feel like even in her 2018 filing, she says to Mike in there, or she says to the court about Mike, she brings up how horrific he was to her, mentally and emotionally abusive he was to her because she would not get over the abortion. And he wasn't being supportive. And she had all this anxiety and depression from the abortion and all of that. So I don't see why it wouldn't be important, but okay. Same response about the correspondence with Dr. Yi. Both of these alleged to be fraudulent and never happened from them. San Francisco police report when Mike called, the police record from 2018 relating to third-party investigation, not linked to Marraccini and not part of the domestic violence record at issue. The photograph is cumulative and lacks authentication. Oh, okay, I'll give them that last part. Image of Laura with redness around her face. Undated and unauthenticated photograph offered without foundation. Laura's medical appearance years prior has no probative value on current fear and risk. They really are sticking to that. I mean, I get it, but obviously they want the whole report by John Berryhill out. We already read all those reasons why. Protection against Clayton has no relevance to this, apparently, is what she wants to say. The subpoena issued by Court of Arizona to Mike. We've already went over that. All right. A civil complaint against Greg. Already went over that. She just says it's remote and irrelevant and offered only to attack her character. And her order of protection against Greg. She wants the positive pregnancy test out from 2016. This has nothing to do with anything. Basically, she wants all of these things out of the way. She wants the Facebook post of her celebrating with her dad, as it contains nothing, no connection to alleged abuse or current apprehension, introduced only to harass. Except that was when she supposedly was, miscarrying twins. She's supposed to be lots of blood coming out of her hoo-ha, and she's in a white dress drinking at her dad's party. So I think it's relevant, but okay. Her deposition transcript from the Eckerd case, she just said it's separate and hearsay and unrelated. Unrelated to Mike. It's all hearsay, apparently, of her being under oath for a deposition, but okay. She does not want the equestrian rider stuff in there at all. Petition order for Greg again. She doesn't think it's important to anything, yet she brags constantly about how she has 3 men. So how could she possibly lie when the courts are like, yes, here, take this one, take this one, and take this one. A text from Laura to Marraccini stating that she loves and trusts you. A single text from 9 years ago predating issuance of the restraining order, unauthenticated, remote, and irrelevant to current fear. Okay. She also does not want her text messages saying, love you, I'm horny, baby, and I wish we could get dinner. Doesn't want those in there. An email from Laura's attorney, Gingras, to Marraccini, where he was like, no, he said he wasn't going to be there. That's enough. Email to media tip line regarding Clayton's update. They said it has nothing to do with Mike. We don't need that. States disclosure. Same, nothing there. Well, it looks like she's just throwing it all out. So nothing interesting. Just it has nothing to do with Mike. And so therefore, no thank you. Just no. I don't think so. I'm done here. She only wants her say. Right? I mean, she spends so much time trying to silence everyone all of the time. It's crazy. It's very crazy to me. Well, what do we have for tomorrow? So tomorrow, I'm probably going to try to come on in the afternoon, probably like 2 p.m. Because I have plans in the morning for our Bestie members and higher. You have what time? I want to say it's 11 a.m. Eastern. Terry and I will be on for Coffee with Terry and Llama, where we're just hang out and talk about things for our Bestie members and higher. Then Terry has midday missing, and then I'll probably come on around like 2 so we can work on wrapping this up. We have quite a bit to cover tomorrow, but it's nothing too lengthy. So we get into her just still wanting things not to happen, what actually happens the day of the hearing. We all know the answer to that. So we will be covering all of those things tomorrow. Thursday, we will finish what all we need to know before the fundraiser. And then Friday, I'm going to do like, we're just going to have a fun Fukong Friday. It won't be very long, but we'll talk all about the fundraiser on Saturday, let you guys know all of the deets, more like a tailgate party, if you will, for Saturday. So that's what we have going on this week. Thursday and Friday will be the same, 10 a.m. Eastern, like we do every single week. We will be here. So except Wednesday at 2. Normally I don't stream Mondays and Wednesdays, but since I missed last week, we had quite a bit to fit in there. So that's what we're doing there. Again, we are asking people, if you weren't here earlier, we're asking people that if you have any words of encouragement or support for Mike or the whole Marraccini family, you can either leave them under our community tab page. There's a post there that also has my and Wink's email addresses. You can email them to us if you would like. I prefer you attach your YouTube handle. Otherwise, I'm probably going to say your first name, but that's it, to give you credit when the time comes. Or you can even record like a 1 to 2 minute video if you want, and we could show it to him during the fundraiser. So try to have those in though fairly quickly. We got a lot of stuff we're doing behind the scenes this week. So that would be super awesome. I think that's all I have for you guys today. Again, clear your calendars for the fundraiser. The link is all for the fundraiser is already scheduled on our YouTube channel. So you can always start spreading that on social media if you want, getting people pumped up about this fundraiser. I know the community is amazing at raising money for the victims in this case. I'm very excited to see what all we're going to raise Saturday. We're going to have amazing guests, auction items. It's going to be, I'll have more news as the days go on each day. So, but that's all I've got for you today, friends. I appreciate those that were here today. I very much appreciate you. And I will be back tomorrow afternoon. So make sure you've hit the the subscribe button. Make sure you turn on the notification bell. You need to hit all. Once you click the bell, you'll see a little arrow. You need to click all so that way you get notified when we go live or drop an episode, because it doesn't automatically do that for you, actually. So Terry and I, oh, you're going to join poolside in Dallas that day? Okay. Well, I'd love to see it. We'll have to see where we can squeeze you guys in, because we got a pretty jam-packed, we got a busy day, a very, very busy day. which I'm so thankful and excited about. If you, for some reason, want to join, just email me as well, and we'll see if we can work you in. All right, friends. I will see you all tomorrow. Until next time, please go forth and be amazing. All right. Bye, friends.